Morning, Fred. Can you hear me?
Yes.
Okay. I know I won't be speaking at all, but I figured I'd say good morning.
Okay.
Nobody else is here yet.
Well, I see some.
Oh, I see some names. Yeah.
I see some names. Everybody's muted.
Oh, okay. Yeah.
Hey, Fred, I didn't expect to see you here.
You didn't.
No.
Oh. Oh, hi, Carol.
Hi.
Are you an appellant today too?
Uh, there's a one on the agenda today, yeah, that I've got for initial means the claimant has opposed the recommended decision.
The message said to sign on at 7:30. I'm not used to 7:30 sign on.
I thought it was 8:30.
Yeah. Well, it is 8:30. I mean, it's
I mean, that's
supposed
the
to.
time I thought it was scheduled for.
It is scheduled for that, but there was something in the notes that said, you should sign on early.
Where is the agenda? Is it on the website? Do you have the agenda?
I don't. I can probably get it.
Yeah.
Good morning, attorneys. Just so you know, you're not muted, so we can hear everything that you're talking about, and this meeting is being live streamed right now. The agenda should be on the website, although we are taking the cases out of order. We'll be hearing sheet first as it's being interpreted.
Thank you. I don't see it on the website, but I'm probably looking in the wrong place.
And my computer has decided to update itself this morning, so I don't have access to the website the way I usually do. You should also have it in the email where you got the Zoom link. It should have been attached there.
So we'll call the meeting to order. Good morning. My name is Ed David. On behalf of my fellow commissioners, welcome to this meeting of the Maine Human Rights Commission. Before we proceed with today, I'm asking each of you who may have an electronic device to, I'm doing this myself, cell phone, pager, et cetera, to ensure that they are silenced now. We have additional agendas, including the consent agenda available in the back of the room and online. The consent agenda is a listing of cases in which no written arguments were made to the Commission in the allotted time. The Commission has voted on those cases or will vote on them. They will not be considered further today. The remaining cases on the agenda today are coming before the Commission to determine if reasonable grounds exist. It believes that unlawful discrimination has occurred. Commissioners have received and investigators' reports and any written submissions submitted within the allotted time. No new information materials will be accepted today. Cases will be called in the order on the accepted agenda. As I call each case, the party who has submitted a written argument will call to the vote. Those relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments. Time limit of 10 minutes per side may not be exceeded. Procedural rules of the Commission specify that your arguments may address only relevant factual errors, relevant omissions from the report of facts submitted during the investigation, or relevant issues and questions concerning the interpretation of the law. The Commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask that you introduce yourselves, as you come to the podium. So we proceed with the business meeting. And first item is adoption of the agenda and consent agenda. Right? So moved. Second.
Okay, so it's been moved and seconded. The only discussion that I have is that someone on the consent agenda, Paz, I don't have the case number in front of me, but is unavailable and was asking to reschedule. I think that is a misunderstanding on their part. Obviously, since they're on the consent agenda, they wouldn't have a chance to present anyway. So I would recommend that we not table that case and reschedule it. Any other discussion on the agenda? B23-0131. The complainant faxed us a notice that they were unavailable. But since we wouldn't have them anyway,
They have not submitted.
they have not submitted a disagreement. They would have been on the consent agenda anyway.
So take that as a motion to preliminary motion to consider that request before adopting the agenda, right?
We can.
Okay.
Hey, my computer. For everybody online and in the room, just FYI, we're all having many technical difficulties outside of our control today. My computer decided to update this morning and it took an hour and has just turned on. And also something weird is happening with the mouse on the computer that we're using to live stream. And so if occasionally the recording turns on and turns back off again, that's the computer doing that on its own. The aliens have taken over, I'm not sure. Anyway, okay, so I'm unclear about Robert's rules on this. Can we have a motion within a motion?
So.
The only other thing I would recommend is that we take Sheedy first,
Right,
as the interpreters are here until 11. That just didn't get through to the agenda.
Okay, let's adopt the agenda and the consent agenda, then consider the motion about the consent, about E23, and then.
If we adopt the consent agenda first.
Why don't we
we'll
amend the
decide
motion
Okay, well,
to,
that's what I was thinking. First.
Yeah.
All right, so we're considering whether to continue E23-0131 on the consent agenda at the request of the complainant, and it's on the consent agenda because the complainant has not submitted an opposition to the report. Is there a motion? I'll make a motion to deny the request to continue. Second. I assume it's no further discussion.
Okay, so we have an amended motion to adopt the agenda as written and to deny the complainant's request at E 23-0131, which would schedule the case.
Right.
Great, okay, so it's been moved and seconded. Any discussion? Okay, seeing none, our commission remote participation policy, I'm doing this from memory, requires that the commissioners indicate their vote both verbally and visually. So if you vote yes, you are in agreement with the motion. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
And so now we'll proceed with the business meeting?
Yes, we need a motion to adopt the minutes
Oh,
from the March
Yeah.
meeting.
So.
Seconded, any discussion?
Correct.
Great. And I remember to give them to you, so that's a plus. Okay, so if you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So now to the reports. You have a memo regarding personnel that I uploaded for you this morning. There have been no changes in personnel since the last meeting. We just continue as we are. For compliance, you have a memo from Jane. We have 5 cases in active conciliation, 3 unsuccessful conciliations, and 4 cases that are ready to dismiss. So I need a motion, so can be all 4 at once. E22-0029, H21-0272, H23-0321, and H23-0335. Motion to dismiss those 4.
So moved. Second. And that's dismissing the conciliation. Right?
Yeah, these are cases where the monitoring is done.
Right,
So they have
you
complied.
gave us the.
Yeah.
Cool.
I have 4 in the drive. Any further discussion about that? If you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. So we had in March was a little quieter in terms of the legislative stuff, so you got a little bit more in the case summary memo. We're just sort of bouncing back and forth between the legislature and the office these days. 47 new cases filed with a total of 68 respondents, 63 withdrawals and dismissals. This was me catching up on withdrawals and dismissals from February. So we had 29 administrative dismissal letters sent, 9 right to sue letters sent, 25 withdrawals with benefits, 7 through the MHRC's mediation program, and 18 through private settlement. I do not have the dollar amount with me right now. I will see if I can get it sometime later in the meeting when my computer finishes updating. We talked about the conciliations. We had no withdrawals with no benefits. So everything that was withdrawn was a settlement with some benefit to the. And I would ask that we take litigation in executive session. Is Jane on the meeting? Okay. This memo says that we have 2 agreements submitted for approval, but I
Will you go get her?
do not think that I have them. No, it's okay. We can do them at the next meeting. That might also be a leftover from the last memo. New business, you have the testimony that we have submitted since the last meeting in the legislature. Answer any questions about those, have them. We are still tracking bills. We have 3 coming up that we expect will impact the MHRA directly. So we'll be testifying on those. So that isn't been scheduled for a hearing yet. And otherwise, we just, bills keep being published. There's four that should impact the MHRA because one of ours is on its way. We sent it back for some revision.
What about the one about, the, to include affiliation?
That one got voted down in committee, so the report out of committee is ought not to pass. There is an ought to pass as amended minority report, which would narrow the definition of political affiliation somewhat, but not the areas or not all of the areas of jurisdiction. So we had talked at the work session about New York and California, where political affiliation is much more narrowly defined and the only area of jurisdiction is in employment. This amendment would narrow the definition basically to activities related to a political campaign, but kept some public accommodation, kept education, took it out of housing. And I can't remember if it took it out of credit extension or not, but so we reduced our fiscal note by half, basically. But because it still included those other areas of jurisdiction, we kept some participation.
How many on the minority?
I don't remember. At least one.
Okay.
I think there might have been 2 or 3, but
Is that sufficient to send it to the full?
Oh, anything.
Any,
Yeah.
yeah, just minority?
Yeah.
Just one.
yeah, just one. Yeah. All right.
What
So
about the other one? I read what you gave, the Chevron rule. Can you say you're tracking that?
yeah, so that one has had its public hearing, and it will. The next thing that will happen will be the work session that, as far as I know, has not been scheduled yet.
I think it just got
Well,
scheduled.
maybe it got scheduled this morning. Things are changing pretty fast. I'm signed up for all of the listservs for all of these committees, and I just get like 70% of the emails I get now are them being like, oh, we've added a public hearing, or we've added a work session, or here's our updated schedule for the week. So they're trying to move pretty quickly, I think, because they have a lot of bills to get through. Any other? I'll keep sending you the testimony as I get a chance. All right. It's 8:45, shall we?
Sure.
Okay.
I still have a procedural question. The difference between mediation and the conciliation.
Yes.
What, if we find reasonable grounds, what's the first offer to the parties?
So conciliation is what happens after the commissioners vote to find reasonable grounds. And in that case, the commission sends an invitation to the parties to participate in conciliation in which the commission is a party. Mediation happens before investigation and the commission is not a party to those agreements.
Although the deferral into the mediation process is before a recommendation.
So
It's already
yeah,
been done.
so what happens is we get the complaint,
Right.
the answer, the complainant's reply, and then Michael and I review the file and decide whether it's a good candidate for mediation, which we almost always do. We invite the parties to mediation. If they both accept, then we refer to one of our mediators. And then if mediation fails, it comes back to us and gets assigned to an investigator for investigation.
And it's assigned to an investigation, but there's no history of that mediation having occurred in it.
There's a pink slip of paper at the back of the file that says
Yeah, but
confidential and
in what
you see, no,
the
because all of
investigator publishes,
Right.
we don't know that it's going to be.
all of the mediation stuff is.
Thank you.
Yep.
All right, you ready to start?
We are ready.
So we have amended the order on the agenda to take the PA 230079 Josh Sheedy versus Concerta urgent care out of order because of the translations. So that is a case in which the recommendation is for finding of no reasonable grounds, and therefore we will hear from complainant.
Yes, and as with the last commission meeting, we'll give each party 15 minutes because of the interpretation and just Mr. Sheedy or the interpreters, please let us know if you need us to pause as we did last time. We're happy to do that. I will set my timer. And Mr. Sheedy, whenever you are ready, you can begin.
Okay, I am ready.
Great.
Hello, good morning, committee. Commission members. My name is Josh Sheedy. I would like to explain how this works with the interpreter. We're using a deaf interpreter in addition to the team of hearing interpreters because I am deaf. I have grown up deaf and uses sign language, and sign language kind of varies between individuals. And because of my physical injury on the job, that affects my ability to sign. And with the hearing interpreters, working together with the deaf interpreters, if I only depended on the hearing interpreters, I would miss some information. And my physical injury impacts my ability to sign, in addition to being overwhelmed and emotional, which also can impact my understanding or my ability to sign. So American Sign Language is my first language. And I'm able to much better communicate clearly through this process of a team of interpreters, including a native sign language user. So we have the team of deaf interpreter, native sign language user, and hearing interpreters in order to make sure you can understand me completely, as well as me understanding you and this process. I came here today because of my concerns from the services I received at Concentra. And I believe there is indeed discrimination there. First, I'd like to mention that there was not consistent sign language interpreting for my appointments, both physical therapy and doctor's appointments. There was not consistency for either of those services in terms of interpreter provision. Secondly, I disagree with the findings because I was misdiagnosed and then received the wrong treatment plan. Oh, interpreter correction. The work plan, the misdiagnosis, and then a wrong return to work plan. The misdiagnosis also then led to inappropriate treatments. And the reason why the misdiagnosis happened, which led to the next consequences, was because there was inadequate and missing interpretation at times. I make the request. I made the request for my case to be transitioned to my primary care physician. Oh, excuse the interpretation. Please hold on. I'd like to emphasize before I get into this too much is that having an interpreter show up is often not enough. I had many appointments. I had 25 appointments, and for only 15 of those appointments was an interpreter provided, meaning 10 interpreter correction, 10 of those 25 appointments, there was a sign language interpreter. 15 appointments had no interpreter. The preponderance of appointments had no interpreter. Again, my point is the lack of interpretation to convey critical communication between myself and Concentra employees, lacking a sign language interpreter, influenced the entire process of my healing and my care, so that many of the problems stemmed from a lack of communication, ineffective access. I was initially assigned 2 doctors. And throughout the process, I requested that rather than Concentra, I use my primary care physician for this workers' comp case, and I was denied that. So I had to go with the Concentra process, which was not what I felt was effective or meeting my medical needs. My request for the transfer was for 2 important reasons. First, because my primary care physician has my case history. I've been going to the same primary care physician for many years. These 2 newly assigned doctors have no knowledge of my health history. Additionally, my primary care physician was already quite comfortable with providing sign language interpreters to make my communication effective. While with these 2 new physicians who didn't know my case, don't know my medical history, and don't know how to use interpreters effectively, that request was denied. And often no interpreter was actually provided. Again, I want to emphasize access to effective communication through qualified sign language interpreters was essential for these 2 physicians to have access to what I was saying and to understand my case. But I was not provided effective communication, and that led to continued medical issues. I was not able to get the appropriate health care nor the appropriate medical outcome. And for that reason, I documented and have letters from my primary care physician emphasizing the lack of communication with these two Concentra physicians. And then lastly, when I was told on October 13th, 2022, that my workers' compensation was terminated by Joseph Castonia, the interpreter's not sure, 100% sure of the last name, and was told that I could return to work, I disagreed. I knew that I was not 100% healthy and not capable of safely returning to work. I knew that I could not meet the expectations and job requirements in terms of my performance on the job with this injury. That day, October 13th, I had no advance warning that my workers' comp would be terminated. The workers' comp representative just sprang the news on me, and I was frankly shocked. And it had a big emotional impact because I knew physically I was not able to go back to work, and that communication and the lack of communication was a compounding factor on all of this. And with the failure of communication between myself and the medical team was very emotional for me. Additionally, again, I would like to emphasize it was because of ineffective communication, information gaps from the beginning that led to the misdiagnosis, which then led to chronic pain in both my shoulders, which continues to this day. Again, lack of clear and effective communication. I was not able to convey all of the information I needed to the doctor, to the medical team. And so ongoing chronic pain, still to this day, 3 years later, is the result. I would like to mention that throughout my injury, I went to 4 different physical therapists. And with each of them, I've asked the question, based on your assessment, do you believe, in your professional opinion, that I have the potential to go back to work and perform my duties adequately? I asked that question of all 4 of the physical therapists regarding my physical ability at that time. Each of those 4 physical therapists uniformly replied, each one of them said I should not return to work. They said I should primarily rest at home.
Mr. Sheedy, I'm gonna ask you to pause there for 2 reasons. The investigator is saying the responses from the physical therapist is not in the record. And you've also used your 15 minutes of time at this point. So we won't hear anything further from you right now, unless the commissioners have questions for you. I'm gonna wait.
But I'm sorry that my understanding is the reports from the physical therapist is already in evidence, correct?
I don't, the investigator is telling me that it's not, but you have also used your 15 minutes. So, and you had used your 15 minutes right at the time that we got to the piece about the physical therapist. So there are 2 commissioners with questions for you right now.
Okay.
Commissioner O'Brien.
Thank you. Good morning. Uh, I have two questions. The first is, you keep talking about misdiagnosis. Can you explain what that misdiagnosis was? And how, well, I better leave it at that. And the second is, can you explain your, hold on, can you explain, according to the report, it says in your sworn statement, that you said there were no, you were not provided interpreters, and at the physical therapy, and then could you explain why your answer changed as we went along? Thank you.
The interpreters needed a moment to confer. Okay, the interpretation is happening now. This is Regan, a deaf advocate here, and I would like to explain the second part related to interpretation at physical therapy.
Hang on a second, again. I need to talk to Commission Counsel. Regan was involved in the case as Josh's?
No.
No.
I'll say, well,
I know that Regan was involved in the initial filings of both cases, helping Josh do that, so I'm pretty sure we have an NDR from them. Usually, so Regan, the hesitation here is that usually we only hear from one person representing the party. So either we hear from the party themselves or we hear from an advocate or an attorney. We don't usually hear from two people in one hearing. Is there a reason why you're better positioned to explain this than Josh is?
Yes, there is a reason why.
Okay,
What is that reason?
can you explain what the reason is?
Yes, I will explain now. The part about the report, I was his scribe. I functioned as a scribe and I supported his English because he would sign it and I would help put those into written English. And during the meeting, there was no deaf interpreter there. The investigator asked questions and the hearing interpreter would respond, but there was no deaf interpreter like there is today to make sure there is clear and accurate communication. I am a certified deaf interpreter. I am a language consultant. So without a deaf and hearing team, the communication was unsuccessful, which led to the misdiagnosis as well as factual errors in the investigation. And I functioned as his scribe. I was concerned about some of the issues that came up today and in the no reasonable grounds result. So I hope that clarifies things. In addition to the conflict and the issues in communicating with the physical therapist, there was also issues in communicating with the investigator. For example, that's why we have the deaf interpreter David Kruger here today. And then Josh, if you would like to answer the first question. I'd like to check with the commission. Is it okay that I answer the first question?
Wait, Regan wants to answer, you want to answer the first question, and I apologize, we can't pin Regan because we have, we can only pin 6 people at a time. Are you, Regan, are you and Josh in the same room?
Yes.
If you could, is there a way for you to both be on Josh's camera so we can see you both?
Regan said she is done with what she wanted to say, her testimony. So she only wanted to respond regarding the second question, and then I'm going to answer the first question. And this is Josh speaking.
Okay. All right, sure. Go ahead, and if we have commissioner questions for Regan, we may ask Regan to come onto the camera. So Josh, you can go ahead with your answer.
Okay, great.
Yeah. Josh is still answering the question.
Simultaneously.
Yes, he is still signing. We're waiting for the deaf interpreter to render the interpretation. In July 29th of 2022, I had an appointment with Dr. Dale, and no interpreter was provided. No hearing interpreter, no deaf interpreter team. They told me that the video interpretation machine was down, which puzzled me because they had computers working and the same internet technology, and I couldn't understand why we couldn't just access an interpreter on the screen. The bottom line was they ended up suggesting, rather than getting an interpreter, they would write on a whiteboard with a black marker. And I was writing in English, which is my second language, which was ineffective. I couldn't adequately communicate the depth of my pain and exactly how I was feeling to the doctor. They sent me for an x-ray and determined that there were no broken bones and told me merely to ice it and take medication. Again, I was in horrible pain. Finally, on September 6th, after repeated appointments, the doctor realized that the July appointment, July through September, those months, I was in continued pain with no alleviation. They realized that I finally got the correct diagnosis on September 6th, which was tendinitis through an x-ray. Oh, excuse me, interpreter correction, through MRI. That's when I finally got the correct diagnosis of tendinitis.
Okay, thank you. Does that answer your question? Okay. Commissioner Douglas?
So, Commissioner O'Brien adequately
Okay.
covered the ground I was going to go.
Any other commissioner questions for Mr. Sheedy? Oh. Mr. Sheedy seems to have signed off. Regan, are you still here?
The interpreters do not see either.
I don't see Regan or Josh right now. Great. Well. Back.
Oh, Mr. Sheedy has reconnected.
Okay. Great, okay. We haven't done anything, Mr. Sheedy. We were just waiting for you to reconnect. Any other commissioner questions for Mr. Sheedy? Seeing none, Mr. Sheedy, you have used your time, so we're going to move to the respondent, which I believe is Attorney Eisenberg, and you will also have 15 minutes so that we have adequate time for interpretation.
Thank you. Good morning, commissioners, Mr. Sheedy, and interpreters. I am here on behalf of Concentra, and I'm here to speak in favor of the investigator's report. But first, I must tell you that there have been many issues raised in Mr. Sheedy's presentation to the commission that are not part of this case and should not be considered by you. They have not been briefed. They're not part of the record. There is nothing in his complaint or his record alleging any misdiagnosis, any inappropriate treatment. There's nothing in the record regarding a request for a transfer to another caregiver or a denial of such transfer. And in fact, any such request would have been made to his employer, not to Concentra. Concentra is an occupational health practice where he was directed by his employer to go for treatment for a workplace injury. We have no communication with the employer about any requests for transfer of care. So that is all new information, new allegations raised today that are not part of the record before you and should not be considered.
This is the interpreter team. Can you please slow down and pause in between big concepts?
Sure.
We'll need a moment to catch up. Thank you.
May I continue?
Yes, thank you.
What the investigator correctly found is that there was no denial of accommodation and reasonable accommodation, and no denial of services, no exclusion from a public accommodation. The complaint included many demonstrably false allegations, the key one being that no interpretation services had ever been provided to Mr. Sheedy at Concentra. This was plainly demonstrated to be false, with the inclusion of invoices for the interpretation services that were provided. That false sworn testimony in his complaint undermined his credibility with regard to other details. And in fact, his allegations about the number of times that interpretation was provided has varied at every turn. It was acknowledged at his conference with the commission investigator that it was in fact sporadically provided. Today, he said that it was provided at 15 appointments, but the record demonstrates that at 17 out of 19 of his original PT appointments, there was interpretation, and that when he came subsequent to the initial 23 appointments for a second injury, he arrived unannounced. He was told interpretation could not be provided on the spot, but an interpreter was provided for his follow-up visit. So that's an 18th time. Those numbers have not been credible. And the fact is that he did not request interpretation at his first visit. There's no documentation of that in the record. And the caregivers were able to communicate with him using a whiteboard. It was in fact, the record reflects that he never requested an interpreter, but that Concentra offered interpretation by the time he came to his second PT appointment, determining that it would be in his interest to have an interpreter. And once they secured an interpreter, the interpreter regularly attended. I think after that, there was only one visit where there was some sort of scheduling problem or other reason that the interpreter didn't make the visit, but they were there for every subsequent visit. Other than that, once Concentra offered and secured an interpreter. Once that treatment was complete and he showed up unannounced for a new injury, there was no interpreter on the spot, but one was quickly obtained for the follow-up appointment. Furthermore, even including the visits where there was no interpretation, there's simply no evidence in the record that he was denied care, denied access to care, or otherwise treated differently. The nurse made objective findings on the exam, and there is no indication that the treatment would have been different with an interpreter, although he today claims that he was unable to make that the extent of his discomfort known. As the investigator correctly observed, there's just no proof that those complaints would have overcome the objective findings on the exam. I therefore encourage.
Could you hold on 1 second, please?
Sure.
Okay, thank you.
I therefore encourage the commissioners to consider the record that is before them that was developed through the investigation process, and to ignore the new allegations made today that are not part of the record regarding diagnosis and treatment and other care providers who are simply not part of this complaint. And to endorse and adopt the investigators' findings and vote to find that there are no reasonable grounds here.
Thank you, Attorney Eisenstein. Any commissioner questions for the respondent? Okay, seeing none, we have heard from the parties. We will next hear from Investigator Beauchesne.
Morning, commissioners and parties. I think most of the salient issues in this case have already been discussed, but just to go over quickly from my standpoint. Number one, there's nothing in the record to confirm that Mr. Sheedy requested an interpreter at his initial medical appointment. There was indication that he used some type of a note app to request an interpreter, but it's not known whether or not that request was ever shown to any hospital personnel or conveyed to the nurse in question. There's also no question that an interpreter was not provided at the second appointment he had a couple days later. He showed up unannounced before one of his PT sessions. And again, at that time, he was examined again by the nurse, but there's no indication that he requested an interpreter at that medical appointment either. And again, as the commissioners have noted in this case, unfortunately, for any disputed issue, Mr. Sheedy's credibility is relatively low. As was noted, the amount of times he claims he was provided an interpreter has varied throughout this process. Initially using the absolute term that no interpreter, there was never an interpreter provided at PT. It wasn't a question of having it provided sporadically. He simply claimed that at none of the 19 visits did he receive an interpreter, and the invoices simply prove otherwise in this case, which destroys his credibility. And had it been a difference between 12 versus 15 appointments, certainly one's recollection could vary by choosing the absolute road that one was never provided. Again, as I noted, his credibility on other points is doubted as well. While he has insisted that he did request an interpreter at those first 2 visits, there's nothing in the medical record to support that request was ever made. And I guess speaking quickly about the interpreters who were provided at the fact-finding conference, there was no objection at the time or any request for an additional interpreter to partake in the meeting. So this is the first time hearing that the allegation that somehow his information was misinterpreted as a result of this other individual not being present. There was no objection made at the time, nor after the fact-finding conference was held either. Lastly, just to address the allegation that somehow the lack of an interpreter at these appointments rendered him unable to convey what was going on. Certainly, I fully understand that English is not his first language and that there may have been some issues as far as conveying precisely the amount of pain he was in. But there's nothing in this case suggesting that additional interpreting would have made a difference. The nurse has been clear that the physical findings simply were not there in this case, that the x-rays revealed nothing. And there were no signs of trauma aside from a little bit of muscle strain. So there's nothing to suggest that had an interpreter been able to convey additional levels of pain that it would have rendered a different outcome in this case. As I say, it appears that once respondent was the one apparently that first raised the suggestion of an interpreter, and as noted, at 17 of the next 19 sessions, one was available with one of the errors being in communication, and the other one, I believe, was just some kind of a glitch. So they clearly did their best to have someone available at all of his PT appointments. That's all.
Morning, Bob. I'm just trying to get the sequence. He goes from the injury directly to Concerta without an appointment, correct?
Well, Concerta is the work organization that this company uses to conduct medical examinations and to take care of work-related PT.
And they have on site an app that does interpretation, and was that not working? Is that the question?
That's unclear. Again,
unclear?
it's respondent's position that he didn't request an interpreter, so that discussion never took place. That he apparently was comfortable with the exchange of limited language on the whiteboard.
On the whiteboard.
Right. So again, if we're going to resolve whether or not his claim that he actually requested one, again, we get back to the same point that if he's willing to be inaccurate about the number of times one was appointed, then we have to doubt his credibility with respect to these additional conversations that allegedly.
But the record does reflect that they attempt to use that app in real time, all the time, when somebody comes in with that need, that the app is available, right?
Again, there's nothing to indicate here that had he made that request, that tool could not have been used.
Right.
There was
Okay.
simply nothing to suggest that he made the request at that.
And I'm also confused about the presence or the involvement of doctors. Does Concerta have doctors on staff? Do they review this record? Do you have any medical records?
Oh, well, again, we have the nurse's
Nurse.
report of the 2 visits that did occur. The one on July.
We should check if they're.
They'll let us know if they.
Okay.
Okay, so again, the initial appointment on the 31st was unexpected. It's unclear whether or not his employer might have said, I believe they did say we have somebody coming in, but did not explain any particular need that he had with respect to the appointment. So on that day, he did produce an app that he uses called Notebook that says, my name is Josh Sheedy, I need interpreter. But again, there's nothing indicating that he ever showed that to any hospital personnel or followed up on his request to have an interpreter present. There's not even a reference to what type of an interpreter he particularly needed.
I'm asking you about the involvement of doctors at Concerta. Are they on staff? Do they supervise PT? Do you know?
I'm not familiar with the entire organizational structure. My understanding, having used similar services in the past, is that there's a medical side of the building that takes care of the diagnosis and treatment, and then there was an attached PT aspect on the other side of the building, so that once he was done with his appointment, he would simply go to the other side for his PT sessions.
Thank you.
Yes.
I'm curious about, in your investigation, did Concerta supply information or policies that laid out expectation that medical staff at their facilities are required to document in the medical record requests for interpretation or accommodations, generally speaking? So I'm trying to get at, it's absent in the record.
Yeah.
Is that because the request wasn't made?
That's certainly,
Or-
yeah, that was certainly responded.
Please wait before you answer. Please hold for the interpreters to catch up. Thank you. Could you please repeat that question that was just asked?
Sure. The question is about Concerta's policy structure does it have policies in place that require medical staff to document in the medical record that a request for accommodation, in this case for interpreting services, has in fact been made, right? Trying to get at the absence of the request, as not documented in the record. Is that more likely because Mr. Sheedy didn't ask for one, or could it be staff simply weren't trained, for example, to document in that medical record the fact that a request was made?
We'll wait for the interpreters. Can you just let us know when you're caught up?
We're caught up. Thank you.
My understanding again, as the respondent has noted, that their position is that at neither one of his first two medical appointments was any such request made. I would have no reason to believe that something would not have been included had he specifically said to the nurse, I need someone, let me reschedule the appointment, let me do something like that. Again, my understanding is that as a general policy, as many of the hospitals do, that there is a board out front near where the reception area is that explains that if you need particular services, let us know and we'll do our best to make sure that those things occur. And I have no reason to doubt the representation that was posted in their waiting room as well. And as Mr. Sheedy did note in his complaint, unfortunately, he spent apparently a couple of hours sitting there. So I have no reason to believe that he would not have had access to that information while he was waiting there. And as I say, and there's nothing in the medical notes suggesting that he wanted to reschedule or to take some other steps to have the information interpreted.
Other commissioner questions for the investigator? Seeing none, we've heard from the parties and the investigator. At this point, we'd be looking for a motion. There is one proposed finding. Commissioner O'Brien.
I move that there are no reasonable grounds to believe that the discrimination occurred.
I'll
Is that it? Yep. Commissioner David, that was you second.
Yep.
Moved and seconded. Any discussion? Commissioner O'Brien.
Well, I'm not sure that I should be so blunt, but I will, because that's who I am. So it just boils down to the word of credibility. That's all I have to say.
Commissioner Douglas?
Yeah, I'll just add, I agree with Commissioner O'Brien, and I'll just add that it doesn't really appear that the complainant was denied any medical treatment here and went in. He had complaints. There was an x-ray. The x-ray showed no broken bones. He was diagnosed with a muscle strain. There's been a lot of talk about misdiagnosis, but there's no evidence in the record that anybody was misdiagnosed. And then he had a number of PT treatments. I mean, it just doesn't seem like he was denied services. It seems like Concentra, on the contrary, provided him very decent care. To the extent there's a dispute between, what the complainant feels his injury is or the severity of his injury and what the medical provider feels that it is, that's not discrimination. That's just, that's something that happens every day in doctor's offices where somebody comes in and says it really hurts and the doctor says, this is what I see. This is how I'm going to treat you. So I just don't see any grounds for discrimination here.
Commissioner David.
I fully agree. He's invested in trying to find a reason for what he perceives to be his continuing pain and blaming that on lack of translation services. But the record indicates that we're not going to second guess in a finding here that Concerta has denied him services based on this record at all. They're doing a reasonable job in providing services all the time. and on request. So I don't perceive any unlawful discrimination.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you vote yes, you are in agreement with that motion. Commissioner David,
Yes.
Commissioner O'Brien. Yes. Commissioner Walker,
Yes.
Commissioner Douglas,
Yes.
Commissioner Sanders.
Yes.
So the findings are no reasonable grounds. We thank the parties and the interpreters for being present and for your assistance in this matter. And the commission will send a letter to the parties regarding the findings, and we will make sure to have that interpreted as well.
Thank you.
Want to break down?
Yes,
All right.
5 minutes.
We'll be in an adjournment for 5 minutes.
Tell your cheeks. Scavels, put the scissors down. What I was doing before. Then why isn't it me? My child. Not yours.
So we'll call the meeting again to order, and the next case is Samuel Lazingu versus Abbott Laboratories. The recommendation of the investigator is for finding of no reasonable grounds on both counts, discrimination and retaliation. And therefore we would hear from the, excuse me, the complainant.
Steve is Attorney Webert. I'm pretty sure I saw you.
Good morning, David
Morning.
Weber.
Attorney Webert, you have 10 minutes. Would you like to reserve any of your time?
Yes, please. 3 minutes.
All right, whenever you're ready, go ahead.
Thank you. Good morning, commissioners. David Weber. I'm here with Sam Lazingu, who I'm proud to represent. To be as helpful as possible, I'm going to narrow in and focus in on 4 documents. 3 that exist and 1 that cannot be found and so is presumed missing in action. And I know you were focused on credibility in the first case, and I think that's probably the #1 issue in every employment discrimination case. And that's the reason I focus on the documents, because they're my best witnesses at trial. They always show up. They don't change their mind. And for the most part, they were created at the time the events occurred and not when the lawyers got involved and, started framing things. So I think the documents are the direct and closest and fairest way to the truth. So here, and the issue that I'm talking about, just to simplify to our strongest claim, our leading claim that we emphasize from start to finish in the case, is that Sam was fired in part based on his protected activities, assisting the Muslim employees in being able to observe Ramadan in 2022, as was their right. And in particular, they fast from sunrise to sundown, not just food, but they don't drink, including water. So at the end of that day in April, it's a pretty long day. You can imagine the problem that occurs there if you can't get something to drink or eat pretty quickly. So that's the practical, humane situation. Now, the first document that I think is critically important is Abbott's termination worksheet. These documents are Abbott's documents, by the way. I rely on the employer's documents when I bring a case. This is their termination worksheet, and for some reason, I don't think it's mentioned in the investigator's report, but it's obviously the key document, and it lists the reasons for termination in chronological order. And the last reason is March 30, 2022, and it says that HR sent an email providing direction to supervisors on how to manage those employees who observe Ramadan. And it says that after receiving these guidelines, Sam didn't follow them, and he was basically insubordinate. That's the final reason given for his termination. So it's pretty obvious that that is a causal factor when it's the final reason in the employer's own statement of reasons. The investigator's report lists all these factors and then leaves that one out with no explanation. But that's what the document shows. That's the document the judge and jury are going to see in this case. And so that is direct evidence that he was fired because of his activity relating to Ramadan and trying to accommodate the employees. Now, that doesn't mean he wins, because if he did something that was truly insubordinate or, totally inappropriate, they would have grounds to terminate him. But it's a very dangerous defense. It'd be like, a woman making a complaint of sexual harassment, and she did it in such a, boisterous, loud, obnoxious way that we're going to fire her because she was, out of line. That's not legally impossible, but that is a very tough defense. So this case is on thin ice for the employer based on their termination document. You get no sense of that from the investigator's report, but that's why I'm taking this case, is because the employer's documents prove the case for me. That's how most of my cases get to court. So then this March 30, 2022 document, which is their big document that provided clear instructions that he violated, they can't find it. They've never produced it. Do you read about that in the investigator's report? Their key document they do not produce. And in their close of evidence submission, they say that's because we have a 30-day retention policy. Now, the investigator needs to question that, right? That's illegal. The EEOC requires a year of preservation. It's illegal under Maine law and just common sense. When you fire somebody for violating an HR email, you keep that with the personnel file. So they should lose just for that. And there's going to be an inference at trial that it doesn't exist. So the case is beyond even chance of winning already. This is not a close case. Then you get to further documents in the employer's own documentation, which is they produced Sam's email on April 2nd, where he says what he's going to be doing. It's the first day of Ramadan, and runs it by everybody and says, please let me know if you want to fine tune this or if you have any ideas. It's not an insubordinate email, but you never hear about it. It's never discussed in the investigator's report. And then on April 3rd, he has text messages with his supervisor about the accommodation they made together for Ramadan for the employees. And the supervisor's inquiring about how it was implemented. And Sam explains and confirms how it was done, which totally confirms this was not a rogue insubordinate action. Now, this was Exhibit 1 to my close of evidence submission, not a word in the investigator's report. Not a word. This is the supervisor on April 3rd communicating with Sam. So these documents make a compelling case. And then finally, just so you know that what Abbott says about the March 30 email they can't find is they say, well, we do know what was attached. A prayer schedule and a prayer, something about praying, and then a schedule for Ramadan. Well, when you look at those documents, they're about praying. And Ramadan does not have a different prayer schedule. The prayer schedule is year round. What Ramadan has is the fast from sunrise to sundown. And in 2021, every day an ambulance was coming because people were passing out. And everybody knew this had to be addressed. Sam knew it, and it was the smart thing to do. So this idea that they had addressed it is completely contradicted by their own records. So this is a case proven by the records. And I just would add that as somebody who's, I go to court a lot, this standard being applied in this report is so much more strict than what the court does and what a jury would do. And just one example, the report says there's no evidence that Sam's supervisor talked about his church unfavorably or assumed that everybody who was Black was in his church. And it says there's no evidence of that, even though Sam signed a sworn charge and then a declaration under penalty of perjury with his close of evidence. So this report is saying things sworn to by the complainant are not evidence. Now that cannot stand at the Maine Human Rights Commission. And the contrast is Abbott was asked for statements signed by decision makers, and Abbott said, we're not going to do that. We don't think it's worthy of doing that. They refused your request. So we have—
That was 7 minutes, Attorney Weber, just so you know.
Thank you so much. I appreciate that. So my point here is that the documents are much more than an even chance of winning. I wouldn't take the case if it didn't have a stronger than even chance of winning. The documents are compelling, but the report is just full of things that just don't comply with how this is going to be treated in a court. So it's a much higher standard in this report than would be in court. And I don't think that really lines up with either the mission of the Maine Human Rights Commission or your standard for finding probable cause. Thank you.
Commissioner, questions for Attorney Weber? David.
Attorney Weber, the investigator found, it's paragraph 13 in the factual background, that the complainant instructed one of respondents' trainees to certify a subordinate who was a new machine operator as fully trained, knowing that to be false. When I read that, it struck me that's a very serious violation, and yet it's not emphasized other than stated in the investigator's conclusion. What's your response to that?
Well, first of all, my response is that the employer's own explanation of why it terminated him ended with the March 30 email. So the question is, did the employer discriminate? So we have to look at what they said with their reasons. Secondly, this is a complete lie and was never run by Sam. In other words, he never got any discipline for that. He never got told about that. It's just in their reasons for termination right around the time that he made this accommodation so the employees could observe Ramadan. So it's not true. We didn't have any kind of fact finding in this case, but we totally dispute that. But he wasn't even given a chance to respond to that, which goes to show that that's not the reason they're giving. The reason, their final reason was the March 30 email, and they emphasized that.
It was stated as a reason.
I know, but this is the thing. Causation, all I have to show, it's one of the factors that made a difference. The final factor, the straw that broke the camel's back, the Supreme Court has said repeatedly, that is a causal factor. So you're getting distracted by some other reasons. First of all, it's false. And second of all, it doesn't make up for the fact that they relied on his protected activity to fire him. It doesn't matter if they have another reason, even if it was legitimate, which it's not.
And your position is that the firing, that the other factor was on, now we won't.
But he's still, yeah, it's just the camera.
That the firing was based on the protected activity and not racial discrimination, not on.
It doesn't, well, life isn't that simple. He's accommodating Black people in Maine with white supervisors, a white supervisor, and he's Black. And they're assuming he belongs to a church. He's actually Christian, a pastor. The other Blacks are Muslim, but to this white supervisor, they're all Black people. They must all be in the same church. So it's not, when he's accommodating Black people, you've got intersectionality with race discrimination and religious discrimination. So it's not that simple. It's not all or nothing. It's not, you can discriminate on the basis of race and religion at the same time when you're mistreating Black Muslims from Lewiston who are working in Maine. That's not I'm sorry, but that's not an implausible story, I'm afraid.
Other commissioner questions for Attorney Weber? Seeing none, you'll have about 2 minutes when we come back to you. Attorney Massey?
Morning, thank you.
And
And
so
so I also
reserve
would
your
like to
time?
focus.
Sorry, did you want to reserve any of your time?
No, thank you.
Okay, whenever you're ready, go ahead.
I also would like to focus on the contemporaneous documents in the case, specifically that termination worksheet, which of course is dated just shortly before the termination and does refer to many reasons for the termination, many of which happened just the month before. So there's documentation of serious performance deficiencies in March 22, which is right before the termination. And in addition to that termination worksheet, in response to the investigator's request, Abbott provided documentation of those serious issues. And so there's a record of performance that's in the record, and that is from March of 2022, and that lists 6 different serious issues that the company was addressing with Mr. Luzingu. And then we provided to the investigator 2 documents also supporting reasons in the termination worksheet. One is a record of that falsification of training records, and another is a complaint by another manager who felt that complainant was treating folks from his church more favorably than others. And so that also supports one of the reasons in the termination worksheet. And it seems that complainant has now shifted the focus from a race claim to this religious retaliation claim. But it's important to note that the investigator actually asked the complainant directly to provide any request for accommodation that complainant had received as manager from anyone seeking accommodation for Ramadan. That was in the information requests. Complainant completely ignored that request in his response and provided none. And Abbott is not aware of any. In other words, complainant is not able to substantiate a claim for retaliation when there were no requests for accommodation that he's using as his protected activity. He hasn't provided, even if he doesn't have access to anything in writing, he has never mentioned the name of a single person who requested an accommodation. So there's nothing to support any retaliation claim. There are many reasons listed in the contemporaneous termination worksheet supporting the termination of complainant. And complainant did not provide information in response to the investigator's request. So I wanted to just talk about a couple of other points that were raised. This text message that was provided on the last day, I believe, that we were allowed to provide information, Abbott did not have an opportunity to respond to it because we're not allowed to respond to anything that's provided with the final response to request for information. But it's been mischaracterized. You need to look at the actual text itself. It doesn't, complainant's counsel is reading a lot into that text for which there's really no further support. And Abbott does dispute that any manager agreed with complainant's plan before or at any time. And also, there is no protected activity. This is new information, I think, about every day ambulances were coming to the site the year prior. I don't believe there's any support for ambulances coming every day in the record. And then as to the race discrimination claim, plaintiff has never pointed to any comparator who is in a different protected class, meaning not in the same protected class as complainant, who was treated more favorably. That's all that I have. Are there any questions?
Commissioner, yes, Commissioner Sanders.
Great, thank you, Attorney Massey. I'm curious about Attorney Weber's assertion that there's a missing document here, right? That is important in the context of understanding what happened here. Attorney Weber also noted that there is some kind of 30-day retention policy for documents that would otherwise be included in the personnel file. So I'd like to hear more from you and very specific response to those concerns that Attorney Weber raised.
Of course. The only piece of information that's in the record is that Abbott has a 30-day email retention policy. We're only talking about emails here, not personnel files. And of course, there's nothing illegal about having a 30-day email retention policy. Many huge companies have that. Now, if Abbott had received notice of a claim or complaint within that period, it would have changed the default policy for emails that were related to the complaint. That did not happen here. And so the termination worksheet refers to an email that was sent a few weeks before the termination worksheet. And that is contemporaneous. So there's no reason to believe that worksheet is wrong. They just didn't copy, to a PDF that email at that time. There's certainly no obligation under Maine law to print every email and put it in a personnel file. And so I absolutely disagree with the contention that Abbott did anything illegal in having an email retention policy of 30 days.
Is that still your position though, Attorney Massey, understanding that, Maine law requires documents that, are relevant to character, work habits, a variety of matters, right, relevant to the employment relationship, regardless of in what form those documents are maintained, right? Those documents are properly part of the personnel file. Understanding that, does that change Abbott's position about the status of that particular missing document?
It doesn't change the position. If you look at the termination worksheet, that is actually much more than a lot of employers do to comply with documenting the reasons for the termination and saving those documents in the personnel file. It's not reasonable to expect every employer to do an email search at the time of termination and preserve those documents. It's really just not feasible. So absolutely, that is Abbott's position.
Sorry, not to belabor the point, but even understanding that, right, at least with respect to those, enumerated reasons in support of the termination of employment, one would think, right, I'll push back a little bit, one would think that documents relevant to the reasons that support the termination, right, it's appropriate and prudent and compliant with law to segregate those documents and save them as part of the file, right? Understanding the employer would need that in a variety of contexts, right? So would need it in the context of terminated employees, application for unemployment benefits, would need it in the context of defending a claim here at the commission, for example. I'm curious about Abbott's position in that regard.
Oh, I understand your concern. It would be ideal if we had every document from the time period, but it's just not realistic for an employer making the types of decision it is every day to have every document related to it. There's a lot of documentation here, and we provided it to the investigator, and the investigator found it compelling, including Mr. Luzungu's email, which was part of the reason for the termination. So unfortunately, he didn't reply to the HR email in his email, but we have provided Mr. Luzungu's email.
Douglas.
Yes, Attorney Massey, good morning. Maybe it already flew by me on this Monday morning in the hubbub of all this discussion of this case, but I'm looking at Attorney Webert's statement here submitted, and I'm on page 2, and he says that there is direct evidence of Abbott's discriminatory and retaliatory animus found in its own documents, and I'm reading this. That is, it fired Mr. Luzungo because he flouted this March 30, 2022 email that's missing, right? Providing direction to supervisors on how to manage those employees who observe Ramadan. Understanding that we as commissioners don't get the entire file. Are you disputing that there's a document out there that states that, Mr. Luzungo flouting this March 30 email is the basis for his termination?
I'm disputing that it's the reason for the termination. As you see in the termination worksheet, and I'm sorry, I wasn't looking at exactly what you were referring to, but I think that's what Mr. Weber also said here today, that essentially it's the causal reason for the termination. If you look at the termination worksheet, there was a long series of events that happened weeks before. So in a very short period of time, there were many performance deficiencies. And so I don't know if you're reading from it saying where it says that this was the final or only reason for termination, but there were many reasons for termination.
Oh, I'll ask Dave this question also. I guess what I'm trying to get at, because I don't see it here and I don't see it in the report, is there a document issued by your client that suggests that this was the reason for the termination? That's what I'm asking.
No, I think that we'll hear what Mr. Weber says. I think that he's referring to the termination worksheet and the fact that it's the last one listed, which is also what I believe he said here today.
Okay. All right. Thank you.
Commissioner Sanders?
Yes, thank you.
Relevant to the MHRA though,
Exactly.
not other Maine law pertaining to personnel
Of
records.
course. So curious about the last answer to Commissioner Douglas's question. Is Abbott's position that you're disputing Attorney Webert's characterization of the law, right? So in other words, Attorney Weber argues that so long as there's an impermissible reason, among many, for example, so long as there's one impermissible reason, that violates, right, the protections under the Maine Human Rights Act. Does Abbott dispute that characterization of the law?
I think we dispute it in several ways. So first of all, I'll go back to my point that there has to be protected activity. And here, complainant was given the opportunity to name the individuals who sought an accommodation and did not. And then I don't believe there was any specific case cited, so I would have to look at what cases Mr. Weber is referring to with respect to whether, I think he said something like the last reason is treated as the causal reason. I would have to look at the cases that he's citing to discuss that.
Mr. David.
Did you just say that the employer gave them an opportunity to name specific names of the people that were suffering under their policy or the lack of a break during Ramadan?
I just said that in the investigators' information requests, the investigators specifically asked that complainant provide, and this is, I'm looking at something dated November 12th, 2024. It says to complainant that they provide documentation related to your subordinate's request for a reasonable accommodation. And then the second one is any documentation denying that. And complainant has never said who requested an accommodation for Ramadan, and Abbott is not aware of any. We do not believe anyone did.
But this case is about his complaints about a discriminatory policy under the Maine Human Rights Whistleblower Protection laws, right? In other words, it's not about a specific individual, a specific Muslim individual needing to make a complaint that he or she is being discriminated against. Complainant is complaining about the policy as being discriminatory against the Muslim workers. He doesn't have to name the individuals, does he? What's your position on that?
If you look at the investigator's report, the investigator specifically addresses this in footnote 1 and takes the position that the record shows that complainant engaged with human resources about an accommodation, but he wasn't doing so on behalf of any employee who said they needed any type of accommodation. So it's complainant who is not the same religion as any of these individuals he's allegedly engaging on behalf of is stating that they need something that no one in that protected class said that they need.
You've answered the question, but I'm not convinced that he can't make that, that he can't make a complaint that other people are being discriminated against, even if he's not in that class. But okay, thank you.
Well, he's not saying, for example, I heard a manager say something derogatory about someone in a protected class. He's saying they need an accommodation that none of them said they needed. I think that's very different from other types of cases where a manager might say something about a protected class.
Yeah, he's saying the policy is discriminatory, and the response to that ought to be to evaluate the policy. Does it discriminate with people that are observing on a religious basis the inability to eat or drink during daylight? And that some accommodation needs to be made in terms of the policy. But we're going back and forth. Thank you.
Any other commissioner questions for Attorney Massey? Seeing none, we'll go back to Attorney Weber. You have 2 minutes and 4 seconds.
Thank you. So credibility is king. The employer's answer to you all on page 4, their story on what led to termination, top of the page F, this is the last heading before the termination, claimant violates HR directive regarding Ramadan schedules. So, I mean, opposing counsel is not speaking today consistent with her own answer that she filed. So not only is it their termination worksheet, but it's the answer they filed with the commission, which is all going to be admissible in front of a jury that's not going to like the new story. And when they talk about this story, they say they came up with a plan based on collaboration with a group of Muslim employees. So they're lying today when they say that none of the Muslims wanted to observe Ramadan and wanted to not be able to break the fast. They're lying about that. And I'll give you another piece of evidence that proves that. The close of evidence, we didn't just submit the text. We submitted a long declaration under penalty of perjury that explained the text, contrary to what counsel is just making things up. And it includes in paragraph 8, this is what Sam says. I reminded Abbott, this is when he's trying to get him to do the right thing, that the previous year, Muslim employees working the third shift who observed fasting during daylight hours for Ramadan became ill and nearly passed out from the lack of a break to eat and rest after a long day of fasting. It is insane to be saying he's opposing a denial of a basic religious freedom, and he didn't out the name of a Muslim. He repeatedly said a bunch of them came to me, and Abbott has admitted to this. They just claim they had a great policy, but when you look at the policy, it only addresses prayer. So they're talking out of both sides of their mouth. At trial, they're not going to get away with that because the documents are going to be up on the screen and the jury's going to be looking at those and the judge is going to be looking at those. And what the counsel says is not going to count for anything except irritation and punitive damages. Thank you.
Commissioner, questions for Attorney Weber? Commissioner Douglas.
All right, so I'm just trying to clarify what the factual situation is here, right? So we have some Muslim employees, they're going to observe Ramadan, right? And your client, the complainant here, engages with the respondent on this issue. Meanwhile, as I understand it from the testimony here today and the report, the Muslim employees enter into some sort of understanding with the respondent. Is that right or is that not right?
That's what Abbott
says. Nodding, that's right.
That's what Abbott says in its answer. I'm saying in their answer, they admit there was a problem and they tried to address it. And now today they're telling you none of the Muslims cared about this. It was totally his idea. So that's the point at which I'm making to you. Not that the Muslims were happy, because the thing they offered was you can keep doing your 5 prayers that you do all year round. That doesn't address the fact they haven't drank or eaten anything all day. So that's why my client's like, I don't want, first of all, it's not good for business to have your employees passing out. And he was a great producer. He got awards for his productivity. There's no reason for firing this guy. And this termination list, none of these things were written up as discipline. They were all like constructive notice. You know, like this is just a conversation about something we're coaching you on. No idea he's going to be fired. They're made up after the fact because they didn't like that he treated these people like real humans who deserved a religious accommodation. And all he did was move the break up. So there's a 40-minute break. They're in a sterile work environment. It takes more than 5 minutes to get to the cafeteria, the only place you can eat. So he put the first break for them so they could eat. Everybody got an equal 3 breaks. This was a very modest, reasonable accommodation. It made total sense because they hadn't eaten all day, but they round up all getting the same number of breaks, the same length of time. And he cleared this with his boss ahead of time, and the text messages confirm that. So this case is not going to be hard for a judge or jury with these documents. And I don't know why the investigator's report, puts it in a footnote. We said this was our leading claim in our complaint, in our reply, in our close of evidence. I mean, read it, and then our objections. So I don't, I try to simplify life. We have other claims, but I'm glad to present that one. So this idea, this is a new claim, read the complaint, read the reply. It's not true.
Thank you.
Any other commissioner questions for Attorney Weber? Seeing none, Attorney Massey, you have 6 minutes and 6 seconds left.
I would refer the commission to that paragraph 8 that Attorney Weber just read parts of. It, first of all, it doesn't say anything about ambulances coming every day, and that's what I was reacting to as new information. And it also doesn't say anything about any Muslim employees who complained to Mr. Lazingu. And it is accurate that Muslim employees were involved in the discussion with Human Resources before the policy went out and had the opportunity to provide input to that. And that's all. Thank you.
Any commissioner questions for Attorney Massey? Commissioner Douglas.
So I just want to understand this, right? Based on the record in this case, what do you feel that the testimony at trial is going to be about these Muslim employees and their satisfaction with the Ramadan policy, we'll call it?
Based on the record here, and of course, it will be different at the point of trial. There would be discovery where we might actually take depositions of employees.
I understand that, yeah.
But right now, what we have is Muslim employees participated in the rollout of the policy. They had the opportunity to provide input. As far as we know, no one ever complained to Mr. Lazingu about that policy. He took it on his own that he had some concerns about it, but there were no complaints by any of his reports.
Right. And as far as you're aware, in terms of once these discussions reach whatever point they were going to reach, nobody is requesting any additional accommodation. I mean, Attorney Weber has said that the whatever plan they came up with just had to deal with prayer, right? So there were no additional requests for accommodation that you're aware of after that from these Muslim employees?
That's correct.
All right, thank you. Oh, I'm sorry, one other question. The performance issues referenced in the report, I think there was some allegation that these were sort of made up after the fact, and I wanted to give you an opportunity to respond to that.
Well, actually, the termination worksheet is created before the termination. So of course, they're not after the fact. They are the reasons for the termination. And I'm not sure if he was referring to something else as being after the fact, but I was talking about the termination worksheet, which lists many different reasons.
All right, thanks.
Any other commissioner questions for Attorney Massey? Seeing none, we've heard from the parties, and we'll next hear from the investigator, Nooper, who I thought was not going to be here, but here you are. So glad to see you. And whenever you're ready, go ahead.
Good morning, commissioners. I really don't have anything to say that's not in my report. However, I am anticipating quite a few questions. So whenever you guys are ready.
Okay. Commissioner questions for investigator Letta.
Okay, never mind.
Space after. Seeing none, we will be looking for a motion. There are two proposed findings. Okay. Oh, Brian, I want to be out of here because it's your name.
I will take them together and agree with the report that there are no reasonable grounds to believe that Abbott discriminated against I'm sorry, I can't pronounce the name.
Mr. Luzingu.
Mr. Luzingu, based on his race, color, national origin, and or ancestry, and there are no reasonable grounds to believe that Abbott retaliated against him for engaging in WPA and or MHRA protected activity, and the complaint should be dismissed.
Motion.
So I propose that we split these, and I would move that there are no reasonable grounds to believe that Abbott discriminated against Mr. Luzingu based on his race, color, national origin, and or ancestry.
Is that the first recommended finding?
That's the first recommended.
First one.
Yeah. You want to take those separately?
Yeah.
Second. Moved and seconded. Discussion?
Well, I mean, I think the basis for this motion is that he's not Muslim, right? And he's not advocating for his own rights. He's advocating for the rights of his Muslim coworkers, right? So he's not being discriminated based on his race, right? To the extent there's discrimination here, he's being, you know, the issue here is he's allegedly advocating for his coworkers. So.
Yeah, I think that's correct. If there's discrimination, it's in the second.
Any further discussion? Seeing none, current motion is to find no reasonable grounds on the first recommended finding. If you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. I have another motion.
I move that there are reasonable grounds to believe that Abbott Laboratories retaliated against Samuel Luzingu for engaging in WPA and or MHRA protected activity.
Second.
Any discussion on this?
Question for counsel, it's correct, is it not, that if the impermissible, the discriminatory factor is one factor among others, that it's still unlawful discrimination.
It has to be a determining factor, but not the only.
A determining, but not the only. Thank you. I think that's a significant point.
Any further, we are still any further discussion?
Yeah, I mean, I think the record in this case on this, the second finding is troubling. I think that, you know, the missing email, the termination worksheet that says,
Absolutely.
you know, that this is part of the basis. You know, the standard is an even chance. I think there's an even chance that complainant could win on this one, so.
Any further discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. No. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay, so the findings are no reasonable grounds as to the first recommended finding, reasonable grounds as to the second recommended finding. So the commission will be in touch regarding conciliation of the second recommended finding. We thank everybody for their participation. Yes, sorry, I did that backwards. We'll send you a letter.
Thank you.
Thank you for your time.
Okay.
So the next case is Calderero versus Maine Savings Amphitheater, City of Bangor et al. And there are multiple recommendations, but there are recommendations for findings of unlawful discrimination against two of the respondents. So I think that we will hear from the respondent.
Yes, so in this case, and I had a question about this, which I thought I would put to you. We have two respondents who have objected to the investigator's report, but for different reasons. Usually we would ask the respondents to split the 10 minutes. In this case, it seems like perhaps we should give them a bit more time. So my proposal, and that's also the complainant, my proposal was to give both respondents 7 minutes each and 12 minutes to the complainant. How does that?
Sounds works for me.
Great. Okay. Shall we take the respondents in the order they're listed as parties? That would be the amphitheater. No, it's the City of Bangor first.
City of Bangor.
All right. So Attorney Koslow, you have 7 minutes.
Thank you. Good morning, everyone. Fred Koslow for the City of Bangor. I've been here many, many times. I can't recall a time where they found no discrimination on my client, and I'm here in an appeal. But that is the case this morning. We certainly agree with the facts that the investigator found, and those being the salient ones were no discrimination by the City of Bangor itself, none. They were not present when any of these actions occurred. They had no notice of any, nor could they have had any notice, because this event occurred in approximately an hour or slightly more. It was at a concert. The individuals involved were not employees of the City of Bangor, nor does the city have the right to control the employees of the leasee. And where the fundamental flaw with this is that the finding was you indirectly put on a concert. Well, the city leased this property to a concert venue, but it's not unlawful to indirectly put on a concert. One has to discriminate. And as I pointed out, there are situations where there is vicarious liability, and that might be in the structure itself, which makes sense because if a tenant has to do structural repairs or that kind of thing, they want to make sure that they probably don't have the resources nor the desire to do that because they don't own the facility. But in that situation, I did find one housing case where a landlord was responsible for a tenant, but in that case, they had notice that there was, rampant discrimination in the building, and they did nothing to resolve it. And so it wasn't really vicarious liability in that case. What it was just their own omissions that brought them into the litigated process. But here, the city didn't do anything. They have to have some intent. They have to do something. What they've done essentially is set up a strict liability that a landlord is responsible for every action that a tenant or their employees do, and that's simply not the law. In these stadiums all around the country, many are owned by municipalities: Los Angeles, Chicago, New York. The city is owned, but they lease these properties. And to suggest that if a hot dog vendor, does a racial slur to some person in the stands, that the city would be responsible for that, there's just simply no legal support for that whatsoever. It does say indirectly, but it's indirectly discriminate. How does one do that? One gets a third party. Why don't you discriminate for me? Or you do something that has a discriminatory result that maybe is in some way indirect. But in this particular case, there's no notice, there's no opportunity, there's no discrimination. It's not a factual issue, it's just a legal issue. And to extend vicarious liability, we all know that you're not responsible for someone else's employees. And particularly in this case, with no notice, no opportunity to resolve it, and just whatever you do over there, anytime, anywhere, any person, the city is liable for whatever happens. That's just not the law. One has to have some sort of notice or something. Now, I understand, and I've given you a couple examples where a landlord could be, and I'm not suggesting in some circumstances or some particular factual pattern that a city could not be liable, but not in this one, because you at least at a minimum have to have notice and opportunity and the ability to control, of which the city had none of them. So we agree with the factual findings, but there is a limit to vicarious liability, and no particular case was cited that you are responsible for absolutely any action by any employee of a leasee. That's a huge jump from what we know the law to be. And it's not the law, and it shouldn't be the law, because that's extending liability to to anything. For yes, the city leased the property, they got a benefit, but that's not any different than any other lease situation. So all the factors that she had, well, you knew it was a concert venue. So what? Everybody knows it's a concert venue. Does the city use it sometimes? That was another reason. The city used the facility when it's not being used as a concert, but that's not relevant to the issues that are presented before the board. And so it's a single issue, but there's no legal basis to tie the city in under the facts of this case. Thank you.
For Attorney Kozlo, Commissioner Douglas.
Attorney Kozlo, good morning.
Morning.
I want to say that you greatly undermined your own legal arguments by that unfortunate reference to the Kansas City Chiefs. I'm an Eagles fan, so.
Well, unfortunately, I did look up the Eagles too, but the Eagles, their city doesn't own the stadium. I did. That's why I broad-based it with Chicago, Los Angeles, and New York too. I figured we'd get there.
You'll remember that for next time. Say, I was curious. You said there's no law cited in the report. I see there's no law cited in your submission, and I was just wondering if you had anything for us in terms of authority on this question of indirectly discriminate.
It's always difficult to find something that's not. If you know what I mean. If there was a case where some landlord was found to be liable, that would probably be reported. But there's no case cited that in other words, we know about vicarious liability. We know what the black letter law is. You're not responsible for independent contractors, all of that. If we're going to go sort of beyond that, we need something. If we're going to extend it that far, we have to show that it's been extended that far. I couldn't find anything to show that it had been extended that far. And it seems pretty far to suggest that, even in Philadelphia, you wouldn't, certainly as the city, you wouldn't want to be responsible for the fans in the audience.
They used to have a court in the stadium. I'm just going to point that out.
No, I've been there. I'm well aware.
It's true.
They did, I know.
Yeah. It's the law school at that time.
Have this discussion.
I hear what you're saying. Thank you.
Certainly.
Any other commissioner questions for Attorney Koslow? Seeing none, Attorney Koslow, you'll have a little over a minute when we come back to you.
Thank you.
Attorney Newell. And then you. Okay.
Good morning. I represent Waterfront Concerts. Alex Gray and Jeff Wielden are here with me from Waterfront Concerts. We are objecting to the findings or the recommendations number 5 and 6, which are recommendations that there were reasonable grounds that Waterfront Concerts discriminated against Ms. Caldera and that they retaliated against her. So I'll address the discrimination first. First of all, I will say that all of the activity that involved both of these allegations occurred over a period of time that the complainant herself has indicated began when the band Fish took the stage and ended during the third song that Fish played. So it was a short period of time. Ms. Caldera testified during the fact finding that she believed it was between 20 and 30 minutes. So there was no finding in the investigator's report with regard to what the timing was, but there's plenty of evidence on the record that at most that was the time period. I will say that one of the flaws, I think, in the legal findings of discrimination was that the incidents that took place, which was a volunteer asking Ms. Caldera and other members in the section in question to sit down during the concert, was restricted only to individuals who were members of the protected class, and that members of the protected class didn't have the advantage of participation in the concert that members who were not in the protected class did, and that just isn't the case. There were both members of the protected class and individuals outside of the protected class that were asked to sit in that section, and there were members of the protected class sitting in other sections of the venue that were not asked to sit down during this 20-minute period. The other flaw in the discrimination piece that I found was that a finding that this was an illegal policy. This was a mistake that a volunteer made. A volunteer believed that that section was required to sit down. And that volunteer asked Ms. Caldera to sit down and engaged other staff in that conversation. And that mistake was rectified very quickly by the venue when it was brought to the top, and they said, no, everybody can stand and dance. And then that was communicated to everybody in the section. Moving to the retaliation piece, this part of the decision I find really perplexing, because in this case, the investigator really found that the discrimination itself was also the retaliatory action. And so the fact that the investigator indicated that it really, whether it was retaliation, came down to one, whether this was just a short delay with a quick rectification of a misunderstanding, or whether her objection to being told to sit provoked an aggressive and threatening response from the staff. The record shows that complainant in her complaint immediately says that staff was aggressive towards her. Staff, the first time that they asked her to sit down, was determined to be aggressive. We deny that, of course, but even even accepting a finding that staff were more likely to have been aggressive than not, that aggression was alleged right from the start, when the complainant was asked to sit. And so indicating that the objection provoked an aggressive or threatening response from the staff, it doesn't make sense, since there's an allegation that the staff was aggressive the entire time that they interacted with Miss Caldera. And again, this all occurred in a very short period of time and was rectified very quickly by sort of moving through different staff and up the chain. So for those reasons, I would ask that the commission find that there were no reasonable grounds for either discrimination or retaliation in this case.
Commissioner Day.
Yes, good morning.
Good morning.
So I have to give you a quip as well here. You said that this all happened very early in the concert. Then you said it was a fish concert.
Yeah.
I actually almost made that comment myself while I was, because I know fish songs are long.
You come out and do this "You Enjoy Myself" thing, right? And two more songs. That sounds like 20 minutes to me. Just
That's
saying.
right. And you know, while and 20 to 30 minutes is what the complainant stated during the fact finding that she believed the timing was.
Okay, well, you may have a problem with that at trial. I'm sure there's a set list out there somewhere.
I'll have to find an expert.
Yeah. Oh, all right. Anyway.
We have some former staff for you.
I'll bet there's a set list out there. Anyway, I just want to make sure I understand your position. So in terms of the discrimination, what I understand you to be saying is that there were people that were members of the protected class and people who were not members of the protected class in this section. They were all asked to sit down. The inference being that they were being asked to sit down because the mistaken understanding here was that everybody in that section needed to be seated. Is that
that's correct?
Characterizing that? Okay, accurately. And then on the retaliation claim, I just want to clarify that you're making sort of like a temporal argument, right? You know, the complainant is told to sit down and there's aggression displayed. She objects, and then the staff goes off to try to figure out what the situation is, i.e. there's no aggression after complainant objects. Is that your position?
No, I think complainant alleges that there was aggression the entire time. But the fact that there was aggression at the start and that was, you know, that was the discriminatory action, was the aggression throughout the whole period, or that was part of, and it was that fact was found to be, the investigator found that to be part of the discrimination. It can't also be the retaliatory action, and the aggression throughout the entire 20 minutes or 30 minutes was found to be the discriminatory action as well.
Gotcha. Thanks.
Other commissioner questions for Attorney Newell? Seeing none, you will have 2 minutes and 18 seconds when we come back to you. Attorney Aiello. And minute.
Good morning. I think it's still morning. Go Eagles. I'm Kristen Aiello for Lisa Caldera, who is with us on the screen. Hi, Lisa. I couldn't disagree more with what you just heard. And I want to go through the facts of what happened here. My client and her husband decided to attend a fish concert at the amphitheater that was scheduled on July 16th, 2022. They purchased their tickets. They got there. The security staff told them the ADA lawn was not accessible and all ADA patrons would be placed on a concrete platform. So that was fine. Also, I want to emphasize that I agree completely with the investigator's report and I'm urging you to uphold it. So I'm going to go relatively quickly through the facts, but they really need to be emphasized because this is such a very unusual case of discrimination at a public accommodation. My client, as the band took stage, my client has MS and some other mobility disabilities. She had a rail there, so she was able to stand. People seem to have an understanding of fish concerts. Most people are standing and, you know, really into it. She stands up and immediately a volunteer comes up to her and says, you need to sit, taps her and says, you need to sit. She goes all the way through the whole section and says, you need to sit to everybody. Everybody needs to sit. The woman came back and tapped her hard again and said, sit down. My client at that point said she preferred to stand and dance in front of her seat. The volunteer said, this is venue policy. Now you're going to hear this again and again. This was not calling a name at the hot dog stand, something that happens off the cuff. This was a long-standing policy. We had testimony from respondents' own witnesses that this policy was in place for years, actually. Said that this is a venue policy and the ADA patrons are not allowed to stand or they have to go to another section. My client asserted her rights at that point. She said, please leave me alone. This is illegal. The volunteer left, it started ratcheting up. Next, a staff comes, the volunteer manager, paid manager of the volunteers comes. This is the one who has testified at the commission, has been employed there for 8 years, said that this is a policy, been a policy for years. The manager comes and says to my client, sit in your seat. My client said she wanted to stand and what other people are allowed, people with disabilities are allowed. She pointed out that others outside the ADA section were permitted to stand. The supervisor told Ms. Caldera she would get another supervisor. So now she's asserted her rights again. We're going up a notch to security. This is where it really starts escalating. A man in a security uniform approached and stood behind my client. He ordered her to sit down now. She explained that she didn't want to sit and she wanted to stand like the others. Another patron nearby asked security where the policy is. Because they keep saying it's a policy, they keep invoking this policy. The security man, and this is where it gets really intense, repeatedly said that he would tell them what is allowed in the ADA section. They could sit or leave. And I'm reading from the complaint and from my client's testimony at the commission. He threatened to have Ms. Caldera physically removed if she stands. The security man stood over her using intimidating postures and gestures. People in the VIP section in the back said she can sit up here. He said no. She had to sit in the accessible space. That's where she needed to be. She called out to an EMT and said, I'm being harassed. The EMT said that there's nothing that he could do. The security man left. She's still standing. He did not like that she was still standing. He came back with 2 more security guards. So you see what I'm saying about retaliation here. It went from you need to sit and then assertion of rights, and threats in her face, yelling. They did not like that she was not obeying and sitting. The security man left and returned. As I said, 3 security men crowded around in her face, ordering her to sit. Ms. Caldera was upset and overwhelmed. She said they're violating the ADA and she doesn't not want to sit. At one point, the security man came close to her and screamed in her face. He was out of control and escalating in what felt like was an imminent physical assault on my client. My client testified to this. We talk about credibility. The investigator did a thorough fact finding with my client, with the head of security, with the security manager who had been there 8 years and said this has been a policy for 8 years. So, and then on the other side of the ADA section was a gentleman with cerebral palsy. He uses hand braces, arm braces to stand. He loves fish, okay? It was his birthday eve. He's the nicest guy. He was so thrilled. He wrote an email to Waterfront after that saying, we felt like we were treated like less than human. He said, he felt like he was being treated less than human, and he was told, they were all told again and again, they must sit. So those are the facts, and these are what this law is written for, the ADA and the Maine Human Rights Act. And as far as the city of Bangor goes, I would understand if this was something at the hot dog stand, someone is, called a name, a racist name even, terrible. The landlord, harder, you can't really necessarily predict that. In this situation, This was a long-standing policy, an open and obvious policy where the people in the ADA section are sitting, are made to sit. We agree as far as the city of Bangor goes that there are times when certainly the law is clear that both tenants and landlords may have an obligation to ensure that their facilities and operations are ADA compliant. The easy case is a physical access, right? The harder case is necessarily a policy issue. But I would say to you that it was such an obvious thing that people in the ADA section were made to sit. No one was ever standing. This brought it to light. Of concern was the owner of Waterfront testified at the Human Rights Commission. And he said, words to the effect, and I don't want to misquote this, but he said, our direction, and this is at the fact finding, which was, I don't know, 6 months ago, it all blends. He said, our direction to folks in the mobility section is that you can stand if you choose. So it sounds like they've changed that, but we prefer if you do not. That was the testimony. So our concern, of course, is the city of Bangor's there, we're there, this has happened, this has been a longstanding policy for years, according to the respondent's own testimony. We're concerned that there's a different expectation still for what people can do in the ADA section. So as far as the retaliation goes, I don't think there's any merit to the argument that someone wasn't very nice and said you need to sit. And just because of that, there's no retaliation after. After Ms. Caldera asserted her rights and repeatedly told the supervisors and management employers who ordered her to sit that she preferred to stand and dance, that this is illegal, that she wanted to stand, that what other patrons are allowed, she's allowed, that others outside the ADA section are permitted to stand. These are all things that she said, because this is over a period of time, right? As different people are coming, culminating in 3 security guards standing over her. I mean, think about that. How would that feel? You're at a concert, you're there with your spouse, you're excited. This happens. In response to Ms. Caldera asserting her rights under the Maine Human Rights Act and the ADA, the Waterfront Concerts and its agents and employees coerced, intimidated, and threatened and interfered with her. After she was ordered to sit, a man in a security unit uniform came over, told her to sit down now, and culminated in a security guard. I've already recited the facts, but he was out of control and escalating into what she thought would be a physical assault. It wasn't until a man in a white, one of the 3 security people, I don't know the name and I couldn't say it here anyway, but a white shirt came in between and calmed things down. Client testified that she asked, are you going to kick me out if I don't sit? And they said yes. So, but things, obviously got very intense. They backed away and stood nearby and just watched her for a while, and her husband. It was horrible, horrible. So we can say, oh, it was just 20 minutes. Oh, it was just 30 minutes. But you come to a concert like that and you get discriminated against like that, and it's not over in 20 or 30 minutes. It's not. It wasn't from my client. And she's here because this is a very obvious, flagrant case of disability discrimination, and we have no guarantee that it's going to stop happening, given the owner saying what he did at the Human Rights Commission investigation. The investigator did a fantastic job on this case. It wasn't a, hey, landlord's responsible for everything. They're not. That's not what this case says. This case involved a very long-standing policy that discriminated against people with disabilities and their companions. So I don't think there's any merit to the argument that, people who didn't have disabilities who were in the section were told to sit, so there's no discrimination. Well, that's not true at all. They were part of the class of people who are associated with people with disabilities. And so they were discriminated against because of association. If you don't have a disability and you go try to sit in that section, you better not be let in. It's like, people who use fake service animals. Terrible. You don't go in that section and try to sit down unless you have a disability, unless you have an impairment that doesn't allow you to go in the other sections of the stadium. So that's my pitch to you. This is a flagrant case. My client was harmed. People over the years, how many people were harmed by being told you can't stand, you're a different class, you're other, because you're a person with a disability, and that's the payment that you have to make in order to get an accommodation. That's illegal. So I'm probably out of time.
You have 52 seconds left.
Oh, okay.
Commissioner O'Brien, and then we'll.
Thank you. Good morning.
Good morning, Commissioner.
Whatever it is, I don't.
Yeah.
Still morning.
Still morning, okay.
It is, yes.
We'll be done.
I'm sorry if I missed this, and I very well may have, but why was the policy in place in the first place?
You know, I don't know. There was something, I can't answer that question. I saw something in the city of Bangor saying something about sound people being able to see or something or operate. I don't know where that came from. I didn't think that was in the record, but it was the policy. Yeah.
Commissioner Sanders and Commissioner Douglas. Thank you, David. So I'm curious about Attorney Koslow is encouraging the commission to adopt sort of, if we, with respect to the city of Bangor, right, if we agree with the investigators' findings, right, the impact is very broad with respect to what this means for municipalities that engage with vendors or independent contractors to perform services within the city limit. I think I heard you say, no, that's not the case here at all. And the distinguishing factor, I think I heard you say, was because there was this policy in place that should have been, right, either was or should have been open and obvious to the city, that in that case, the city's got an obligation to make sure that its vendors and contractors and partners, are assuring compliance with state and federal law. I just want to make sure that I understand that correctly.
Yes, Commissioner, absolutely. And if I could give you an example where I think this is important, let's say you have a school district and that school district has contracts out to a nonprofit entity. This happens all the time. What if that nonprofit entity says, no kids with wheelchairs, we can't deal with that. No boys, they're too active. What if they have that policy? And it's an open policy, it's known. Shouldn't there be some requirement? And I think there is under the law to hold that landlord accountable for that indirect discrimination. I agree there shouldn't be liability for everything under the sun. And I understand exactly what Attorney Koslow is saying, but in this situation, it's different. So that's, thank you.
So the venue policy, right? And
Yeah.
this business about members of the protected class, members of not in protected class being in the section. You just said something about the sound people. Somebody said something about like the sound and lighting people or something needed to see, right? Well, there's something, I'll tell you what.
It is in the record and I can answer the question if it's easier.
Okay, well, it's okay. And then there's something else in the record here in the report. It says, volunteer had the mistaken belief that it was Waterfront's policy that all patrons in section were required to remain seated because of the location of the seating, which sort of dovetails with the sound people and all this sort of stuff. So what I'm curious for you is what is your understanding as to exactly what this policy was?
The policy.
What was the discriminatory policy?
The policy was that no one in the ADA section may stand.
Okay.
That's what I was understood it to be from the record. It was repeated again and again and again. And they all invoked that policy, you must sit because you're in the ADA section.
On the city piece of this, I'm struggling with it, and maybe I have too much of a background in tort law, but I'm struggling with how we hold the landlord responsible when, as Fred says, they haven't done anything. I mean, if this was a negligence case, it's not, but if it was, I'd be thinking, where's the negligence, right? I mean, you said like an easy ABA case, right, is where, there's no ramp, right? Or there's no, there needs to be handicap spaces or something along these lines, right? That's an easy case. As you pointed out, it's a much harder case when it's a policy, right? And what I'm wondering from you is, I mean, what is the city supposed to do in this instance? I mean, are they supposed to review all of the policy? What would you have liked to have seen in this case to prevent this from happening?
Yeah, I mean, I think the city has an obligation to ensure that those that they contract with don't discriminate. And there's things that maybe are hard to control, like a rogue employee who goes off and does something that no one could necessarily predict. But I think that the city does have that obligation under Section 504 of the Rehabilitation Act, for example. Entities that receive federal funds have the requirement that they need to ensure that who they're contracting with doesn't discriminate. So it would be that, you know, it's an open policy that was in place for years. I would expect that the city would be more careful about who they're, you know, that the entities they contract with aren't discriminating. I mean, they have a weighty responsibility. And when you think about this being a facility owned by City of Bangor, and people with disabilities routinely just getting discriminated against and treated differently in direct contrast to the law, I think that's pretty serious too. And I think that's why the Maine Human Rights Act, the investigator quoted, is written that way.
And then just one more question that I'm a little confused from the remarks here. The policy that we're talking about, I'm just going to continue to refer to it as a policy because you did. Was that actually in place? My understanding, it was like a misunderstanding, right? It was in place before and it wasn't in place anymore, but this volunteer thought that it still was. Is that accurate?
No, that is not accurate. I totally disagree with that. The record is clear that everyone who came to my client invoked the policy. They didn't say, oh, the volunteer made a mistake. No, they didn't. They came because they were ratcheting it up because they were enforcing the policy, culminating with the 3 security guards saying, you need to sit or you will be expelled. So no, that is absolutely not consistent with the record and the testimony from respondents' own witnesses and from the ADA, my client and the other patron who had cerebral palsy.
Everyone in the ABA section must sit. Right?
Sorry,
Everybody in that section must sit. That's the policy.
Yeah. Yeah.
Thank you.
Thank you.
I'm confused about who Maine Savings Amphitheater is.
Yeah, I named them because in an abundance of caution. I wasn't sure if I knew that, you know, that just being a careful lawyer, making sure that the name of the entity is there in case there's. But
Do you agree that with the recommendations for 1 and 2, that there's no reasonable grounds to believe that Maine Savings Amphitheater discriminated?
I do, to the extent that it is just a building. It's just the name of the building.
Okay, so you do agree.
I do. It's I would urge the commission to vote reasonable grounds
All right.
against the city.
Do you agree with number 2 that there's no reasonable grounds to believe that the city of Bangor retaliated?
I'm not contesting that here today.
How can you not? Your argument seems to be that this is so outrageous that the sequence of escalating it is what you claim is retaliation. What's troubling me about this is the retaliation. I think we have a fairly clear case of discrimination, but it's all the same. It's all the same incident. But that's where I'm going. How do you distinguish and say if Bangor is responsible for discriminating, which you do, you believe we ought to find that, how can they not be responsible for retaliating, which is what you're claiming Waterfront is responsible?
Well, I would be happy to have a vote that Bangor retaliated. I've been trying to be consistent with the investigator's report. You know, but you know, to the extent, I mean, the retaliation occurred clearly by the city of by the waterfront. You know.
Yeah, I mean, I have a real problem with the city of Bangor being responsible here. And when I first asked you, do you agree that there's no reasonable grounds to say they retaliated? You said yes, and now you're saying, well, if you want to find that, it's fine with me.
Well, I'm trying to be consistent with the investigative report. I think it was well done. I think it was well thought out and accurate.
Different question. This is about a policy. Is this a written policy?
I didn't see it in writing, but it was just stated over and over again that that this is the
Well,
policy.
over and over again it doesn't mean anything to me. These are the same people saying that they think there's a policy. That we have a policy that you can't stand. Does anybody prove that there's such a policy? No, they back away from it and say, no, that's not right.
Well, if there wasn't a policy, it was a practice, it was something that happened and it was discriminatory.
Yeah, but how does that get to the city? The city that's renting their park, they're responsible for the physical space. They would be responsible if there was no access for disabled people, those kinds of physical things. I mean, I'm really having a problem dragging the city into this, although I'm not having a problem with the discrimination by waterfront.
Well, I think that's the decision that you would need to make. I mean, obviously, so.
The other thing was that when we first started, there was some mention of the ADA section and it not being available, so go to this other section. Are they in the ADA section?
Well, my client's testimony was that when she got there, she had expected to be on the lawn.
Right.
For the ADA section on the lawn, and they said it wasn't available, so they moved her, everyone was going to the concrete platform. So
But is the concrete platform designated as an ADA section?
yes, that is it. That is one of the ADA sections. That is the section at issue here that has had the policy in place for years, according to their own management employee.
Okay, so there's the lawn, which is an ADA section, and there's this platform. I also had picked up on this business that they needed to sit because the light and sound people had a line of sight that they needed to see. That's not implicated here. That's not in the record.
I don't recall if it's in the record, but my position is then they shouldn't put the ADA section in a place that would discriminate.
Well said, yeah. But I think that was the excuse, but,
Mhm.
okay, thank you very much.
Thank you, Commissioner.
Any other commissioner questions for Attorney Mayo? Seeing none,
Thank you.
we'll come back to you after we hear Attorney Koslow. You have 1 minute and 18 seconds.
Well, I will talk fast. First of all, one statement by counsel I think was important. She said, this brought it to light. And this incident brought it to light. Now, remember, the only time this would have policy, even if it was in place, but I think there's evidence it wasn't in place when this concert occurred. The only time you would be able to see it, if it's not written, you would have to be only at a concert. I mean, that's the only time it would happen. And so you should have known it. It was in place for 8 years. I don't think the concert venue was even open for 8 years. My understanding was that this Fish concert, after the sort of remodel, was the first thing. So, you know, you should have seen it. There's no obligation for a landlord to police the tenant. And certainly something that is occurring only during a concert, a few hours for a few concerts a season, is not something that the city should have known because it wouldn't have been obvious. And so, you know, that's really when she said this brought it to light. You know, apparently this was the first time that, you know, anybody knew it. And of course, at least from the venue's position, it wasn't the policy even that night. You know, so I think it's so attenuated on the city that you should have known. There's just no obligation to police to that detail. Thank you.
More questions for Attorney Koslow? Seeing none, Attorney Newell, you have 2 minutes and 18 seconds. If there's anything else you'd like to add.
Sure. There were multiple misstatements of fact in Attorney Aiello's presentation. The first is that there was never any indication that the ADA lawn section wasn't available. It was that the complainant had come to the wrong entrance, and this ADA section was much closer and was actually a much nicer and improved section to view the concert from. And because they had space there, they sent complainant to that section. There were multiple ADA sections, including the lawn section that she had originally been assigned to in the facility. And ADA patrons were allowed to stand in all of those sections eventually. And in all of the other sections for the entire time. You're absolutely right that it is in the record that the reason that there were times when patrons were asked to sit in the section in question were related to the mix and the soundboard and the professionals who were providing lighting and sound to the concert needed to see the stage. That wasn't the case anymore here, which is why there was the confusion on the part of the volunteer in the first place. There was no written policy around this. There had been times where individuals in this section, which included both ADA individuals who attended the concert with ADA and protected members of the protected class and other concert goers, all were able to stand within that 20-minute period. The other thing that I want to point out is that there was a big dispute between Waterfront Concerts and their witnesses and complainant as to whether aggressive behavior was displayed. And Attorney Aiello said it was a matter of credibility. There was never any credibility assessment in the investigator's report that Waterfront Concerts witnesses were not credible. That just was never a finding. The investigator found that, well, if you're looking at the preponderance of the evidence standard, there's I guess as good a chance as not that complainant's version would be adopted. But
That is
that
your
was only
time, Attorney Newell.
Thank you.
Commissioner, questions for Attorney Newell?
Yeah, I just wanted to, Attorney Aiello said that if she defined this policy, she can still hear me, right?
Yes.
Okay. She defined this policy as you can't stand in the ADA section, right? And so I just want to confirm, you disagree with that?
That's correct. That's correct. Even when there was a question about standing in that section, it was that you couldn't stand in that section because it was in front of where the sound and light board mix boards were, not because it was the ADA section.
As I understand you to say, that policy was not necessary anymore, right? Because the way things are situated now, the sound man or the lighting person can see, or sound woman can see the stage now without people having to sit, correct?
Right, which was why Waterfront Concerts rectified the issue immediately.
Yeah.
And it was never a written policy in either event. It was I'd say at best a practice that they utilized when they were dealing with situations.
Thank you.
Other commissioner questions for Attorney Newell?
Just one, Attorney Newell, I'm curious about even to the extent that this may not have been a policy, right? That it was staff on that day were simply mistaken. Help me understand though, isn't it true though, even if it wasn't a policy, simply the fact that staff and a volunteer communicated, right, on behalf of the venue that in fact it was the policy, isn't that communication sufficient for purposes of the commission finding that there was a discriminatory act?
I don't think so for a couple reasons. The first is that even if they described that there was a policy of individuals sitting in that section, there was no finding that assertion was based on the fact that it was ADA seating. It was based on the fact that of where the section was, and that was the understanding as to why that policy. So it wasn't discriminatory, and there were other ADA sections that were permitted to stand freely. So if it was just if it was never a policy that individuals in an ADA section have to sit. And so that I don't think it follows that it would be discriminatory at all.
Sorry, I mean, is there anything in the record about what people in the other ADA sections that night were permitted to do, stand, sit, what have you? Is that in the record somewhere, to your knowledge?
Well, yes, it's in the written record. It was, so yes, it's in our response. that others were allowed, that there were others in ADA sections that were allowed to stand.
On this at this particular fish concert?
I believe it's in our response and our final submission, but I'd have to go back and look.
Right,
There was no testimony evidence regarding it or any testimony of other individuals who were in those sections.
That's fair, and I appreciate that. You just asserted that in your submission, is what you're saying.
That's right.
All right, thank you.
Any other commissioner questions for Attorney? Seeing none, Attorney Aiello, you have 52 seconds. Run.
Okay, I just want to share an email that was written 2 days after the concert. It was from an individual with cerebral palsy who said in an email to the waterfront, the venue staff was grossly unprofessional. Many of the ushers and security team were rude and hostile to my friend. At points, I was made to feel less than human. It was as if I was viewed as a problem to be dealt with instead of being seen as a paying customer with the venue. My friend Al, who is also a person with a disability in the section, had a similar experience. We were told to stay seated. We were not allowed to stand and dance. Thank you.
Commissioner questions for Attorney Aiello?
Yeah, I just want to ask the same question. Sorry to jump over.
No,
everybody.
that's fine.
I just want to ask the same question I just asked Attorney Newell. So, to your knowledge, is there anything in the record about people in other ADA sections at this fish concert being allowed to stand? She says that there is. She says there's something in her written submission, but no testimony. And I'm just wondering what your take is.
I don't recall if that's in the record or not. I think it's irrelevant, though, to whether or not there was discrimination that occurred at the ADA section.
Well, I think what it goes to is, what the motivation was for these employees to tell your client to sit down, right? Because there's now testimony that, or allegations that it had to do with the sound, the placement of the sound people. Is this old policy that was no longer in effect, at least according to these folks. And so that sort of, if other people in other ADA sections are allowed to stand, but people in this section are not allowed to stand, that sort of supports that notion a little bit. I think that's where that goes.
Well, I think that they put a price on the accommodation that the people in that section could have, and that was you can't stand if you are disabled and you can't walk. They said in their own submission, Council for Respondents made reference to the ADA section being for people who, I think the words were, unfortunately cannot stand typically. I don't mean to misstate that, but that was my understanding from Council's submission. And then as far as the retaliation goes, the issue there, of course, is whether or not the person was discriminated against. My client was discriminated against because she complained and asserted her rights under the Maine Human Rights Act and the ADA.
Your commissioner questions for Attorney?
Thank you very much for your time.
Thank you.
So we have heard from the parties, and next we will hear from Deanna Riley, who is an investigator in that case.
On Jay.
Me again. You just love it when I'm here. Are we still? I'll say good afternoon, maybe first. No, good morning. Good morning, commissioners. My name is Jana Riley. I was the investigator on this case. Had a lot of coffee. Try to slow down. I am going to talk a little bit, maybe more than I normally would for a presentation. I think because in this case, which does happen in some of my investigations, there are 3 versions: the respondent's version, the complainant's version, and my version. And so I want to sort of clarify what the report reflects and what I feel the record reflects, because I think the parties have very accurately this morning reflected what they have said throughout the investigation. I'll start with the facts of the issue of just waterfront and what actually occurred, and then I'll talk a little bit about where the argument comes from for the city's liability. So I'm going to work backwards. We were just talking about the sort of different ADA sections, the policy in place in this section. So the way the venue is constructed is that there are varying spots throughout the facility. So first of all, anyone with a disability can sit anywhere they want, right? If seats are accessible to you, they're accessible to you. There's no restriction on where you can sit. there are varying types of available seating. So aisle seats that are accessible, an ADA, the section that is the called section in my report is this very particular section that is right in front of the VIP seats. It's very ideal seating, specifically designed for those who may not be able to access the concert any other way, right? This may be the only section that those with certain mobility-related disabilities can see the concert, can enjoy the concert from that particular section. There's also lawn seating in the back, which is just an open lawn, and in the front of that lawn is another section that's called an ADA lawn section. That is also available for people with disabilities to access the concert from that viewing. That is initially what complainant had purchased. That's the sort of dispute about being moved to a different section. She purchased her lawn seating, then requested that she have the accessible seats. They said, great, sure, come to this side of the venue. When she showed up at the other side of the venue, they said, well, it's a really long walk from here to there. Why don't we just put you in this sort of upgraded seating area? To the extent that the policy is not discriminatory because there's other places people with disabilities could sit, that's not really an accurate reflection of what was available to patrons when they came to this venue. That may be the only place where a patron with a specific type of disability may be able to use and enjoy the venue services, the concert, see the concert, enjoy the concert on the same level as everybody else. The policy, the way the policy evolves is it was never a formal written policy. I do believe that the statement by the owner was slightly mischaracterized by Attorney Aiello in that he did say that there was a policy in place based on the location of, so it used to be a grass area. They didn't have this very formal, elegantly built cement. That was a years-long project. When they initially started holding concerts, there were a lot of temporary structures. They had this temporary sort of sound structure seated in front. Seemed like the sound people were kind of asking, hey, could maybe people not stand? They sort of informally did that. Whether or not that was discriminatory at the time is not analyzed in my report. I don't have, there's no standing or allegation based on that policy existing at the time. And then that changed when they built a new venue. The statement of policy at the time by the owner was be a good fan. Which I don't go to a lot of concerts, but I think for people who do, if it's a standing concert and people are standing, let that happen. If it's a sitting concert and there are a lot of people who are going to be obstructed in their view because most people who attend are going to be sitting during the concert, don't stand the whole time and block everybody's view. But there's no set rule on where, there's no sections that are just standing, there are sections that are just sitting. Be a good fan based on the sort of mood of the concert. So my understanding from the record that I have is that that policy was not in place. To the extent it was enforced, it was a mistake. Having said that, my report reflects that even if you have a mistaken policy enforced, if the policy that's enforced is discriminatory, it doesn't really matter whether or not it was a written or formal policy at the time. You can imagine if someone came to a business with a service animal and they said, no service animals here, and it's not the policy of the business, the employee was just wrong, and that person leaves, that person would have still been denied access based on having a service animal, right? So a mistaken enforcement of policy under my analysis is still a discriminatory policy if the policy is discriminatory. I then want to talk about the sort of separation between the claim of the discriminatory policy and the claim of retaliation. So retaliation is based on the discriminatory policy is the terms and conditions argument, right? Complainant, when she attended this concert, was not able to enjoy the concert with the same terms and conditions, being able to stand, being able to dance as other patrons due to her disability because she was in this section that she needed because of her disability and she was told she had to sit. For the purposes of retaliation, you're talking about actions in response to assertion of rights. So if the complainant had a reasonable belief that the policy telling her to sit was illegal, and she said, no, I'm not going to sit because it's illegal to make me do so. And in response to that was hostility that, again, affected her ability to enjoy the, services of concert because of the aggressive and hostile nature of that treatment, that would be a retaliation claim separate from. So you could see a situation in which one or the other happened, right? She is told to sit, and she says no, and someone goes and says, okay, then don't sit, right? You can sit. There's no retaliation for her asserting the right that says it's legal to make me sit, but maybe there's a claim for enforcing a discriminatory policy. This is to separate out the claims. I'm not going to go into if that had happened. No, that's here. But you could also see a situation in which she did sit down, but and the the policy wasn't enforced, or there was some other issue with the policy, but then she asserted a right of an illegal inaction, and there was some sort of retaliation separate from that. So that's where I see the separation, even though, aggressive behavior was throughout, there's sort of all the things happened at once. The policy is a basis for discrimination, along with the response to her assertion that the policy is discriminatory, all come together. But there are two, from my analysis and my view of the record, there are two separate illustrated claims of both the terms and conditions and the retaliation. I'm tempted to pause and ask you questions on that before I talk about the city argument. I'll just move on. So for the purposes of the city argument, I'm just going to say, and Barbara can jump in afterwards once I'm done, that the only law that I'm talking about, the only law the commission enforces is the Maine Human Rights Act. So my interpretation of liability is based solely on the fact that under the provisions of the Maine Human Rights Act in public accommodation, it's any person who is the owner, lessor, so they own the land, they lease the land, to directly or indirectly, and then it includes all bases of discrimination. So if you are an owner or a lessor of a particular entity or land or whatever, and that discriminatory action happened, then you are liable for those actions. A plain reading of that statute says that lessors are liable for discriminatory acts. And I think there's a bit of a, the use of landlord tenant, I'm hesitant to use that in any of my presentations to you. I think there's very specific housing laws that deal with landlords, that deal with tenants, that deal with owner's liability. That's a separate part of the statute. And we're not really talking about a landlord tenant situation here. We're talking about a city that has a plot of land that leases that land out to an entity that provides a public service to its city members that engaged in discriminatory conduct. And as was stated, under our statute, that is one of the ways in which you can be liable for discriminatory conduct, is as a lessor. So again, that's where the reasoning comes from. I can answer more questions about that. But I don't know anything about tort law. I don't know anything. I don't know anything about contract law. The only law we deal with, that we enforce, that I interpret, when I do these reports, when I have my discussions with Barbara, is the Maine Human Rights Act, and that's what it says. So I'm ready for any questions. Yes.
Just pretty basic. I'm trying to get the way of the procedure, I guess.
Mm-hmm.
When a patron purchases ticket, do they request a particular, do they say that they have a disability? And what happens if, and is it specifically for one of those areas?
So yes, there's actually a couple different ways to buy tickets. Ticketmaster, you can buy tickets on and there's some other sort of third-party brokers. If you buy directly from the venue, you communicate with them about what seat, but they're actually different price points, right? So you can buy the accessible seating in the different levels are different costs. So people choose which one they want. You don't just indicate. But in my in the conference that I held when I was interviewing everybody, I talked to them about sort of, again, this reason she was in this section as opposed to her lawn section. And they said, well, as a general practice, we don't sell all of those seats. We keep some aside for anyone who shows up at the venue and may not be able to, even if you purchase general admission tickets and can't access those seats because something happened, we generally have those set aside. So that was just in the moment, that was a sort of service decision to just say, this seating is closer, you can go here instead.
And also, and I've been to concerts there, but it's been a while, so, and not a fish concert. Won't tell you which. But,
the folk fest.
no, it wasn't. Now you come in. Is there the section that the complainant was in? I understand there were actually seats, but when you talk about the lawn area, that is also ADA. Are there seats there?
I don't think that's in the record. So what happened between the time the concert had taken place quite far back by the time we had the conference, it's been almost 2 years. And there was a sort of mid-state of, no one could totally completely with 100% certainty say exactly the state at the time at the conference, I did eventually request some, pictures and things. And I don't want to say for certain what was there. There was no assertion, really. There was no, it wasn't disputed. It wasn't argued. There was no issue about seating in other places. No one was saying that people as a whole were being discriminated against. No one said there were other policies in place. No one, complainant didn't argue. No one could sit anywhere. The whole, one of my footnotes addresses some of the issues she had with the structure access. But I don't even know if she saw the actual lawn seating that she had initially bought tickets for. It was on the pictures of the venue that I have that were given to me. If the stage is down here and looking up at it, and the section is here, lawn seating was like way up in the back over in this one. But at the front of the lawn section.
This is all very helpful. First of all, I want to say that the last time I saw fish at this venue, Commissioner O'Brien was there. There. I saw you. I had pictures. With respect to the city, and the tort law and Fred's arguments, which, I understand where he's coming from. The statute says it's not, it provides for liability against an owner or a lessor, but they have to indirectly or directly discriminate. And I'm wondering, same question I asked these folks, what does indirectly discriminate mean in this context? Because I'm sort of I feel like the city had to do something. So what does that mean in this context?
I can't answer that for you. In terms of the preliminary investigation we do and the interpretation of law in the statute, I'm interpreting it the way I would interpret many other definitions of indirect, which would mean not direct action, right? And in this case, there's a concert on, you're providing a lease to an entity that provides a concert service, and that concert service was provided in a discriminatory manner. You didn't directly do that, but you leased it to an entity that did. And so indirectly, you're responsible for that discriminatory action.
So the argument is, I just want to make sure I understand. The argument is that because they leased the premises, that's the indirect action and they're liable.
Right. So as a lessor, under the statute, because lessors are liable, you'd be both liable for your actions. If you lease something in a discriminatory manner, right? But also if you engaged in conduct through by leasing a service. You could think of it, I think for me at least, it's helpful to think about it on sort of multiple levels. So with the sort of fanciness of the service that's being provided, because it's this full entity with its own management company and there's a full structure built, I think can blur the line between what, the city, like if we had a case here where a city had volunteers for a fun fair in their park that they didn't directly manage, but they contracted out to nonprofit and those volunteers were not allowing Black people in, it would seem a lot more closely related to what the city was doing than a city that's leasing with a large company that has this whole structure. But I think it's the same, I'm looking at it with the same type of lens. You don't get to step further away from your obligation in providing non-discriminatory services just because of the levels of management that exist in between your contract, the fanciness of the contract that you engage in. And beyond that, I think I'm gonna let Barbara answer any further questions. I think that's the limit of where I can interpret that.
Commission counts.
I want to hear.
Here's something that makes sense.
Good luck. This is an area, Jane and I talked about this. There is no case law directly on point that I'm aware of. So given the human chance standard, I think that it's reasonable. I've been scrunching my face up over here because I'm trying to remember. There was a case years ago where someone owned a lot of land and there was a used car business that A, leased the land and B, was blatantly discriminatory. And both were named and then my recollection stops. We held the owner liable. I can't remember any names, so I can't find it in the 20,000 records of cases that I have here in front of me. But there was enough in the record that suggested that the
at least this is my understanding from our conversations, Jane, who's Jan, the city knew or should have known, especially given how they were enmeshed. A lot of their contract is about profit sharing and this sort of thing. The city gets a cut of any tickets sold. So I think there was enough that we decided, given the even chance standard, that that was the position we were going to take, again, in the complete absence of any case law whatsoever.
Barbara, when you say that there's no case law, do you mean that certainly Maine, but also if we're looking at other respective states?
I do not look beyond Maine in this case.
Yeah.
I can see a situation in which the city could be liable. But I don't think it's this one. I want to challenge you the same way I did with Attorney Ayala.
Mm-hmm.
Your recommendation is that this behavior, outrageous as it was, also rises to the level of retaliation. How can you recommend that we find no reasonable grounds that the city of Bangor retaliated?
Because the sections of the statutes are written differently. So in the retaliation section, which is separate from all the sections of the statute that talk about the different areas of jurisdiction, there is a separate retaliation provision at the bottom that says any individual. So it's specifically implicating not, indirect action through contractual relationships or things like that, but a specific individual engaging in retaliatory conduct. So, when you're looking at why you can hold Waterfront, an entity, liable for retaliatory conduct, that has to do with relationship of employee-employer. But in finding retaliation on behalf of the city, there needs to be some conduct that shows that an individual retaliated against. So that's the difference in the findings.
Okay, I'm not finding that difference. I mean, I'm tipping my hand here. I'm having trouble finding that Waterfront retaliated. The behavior's outrageous, and I can find that that's unlawful discrimination. But retaliation, it seems to me, would be something outside the incident of sit down. It's a policy. I'm getting security. I mean, it goes on for 20 minutes. That's the incident. Retaliation would be, and by the way, you're blackballed from any other concerts because you made this complaint. That would be retaliation. So that's what I'm concerned about. But it's an excellent analysis.
If it helps, it's sort of looking at, in terms of my analysis, again, you can disagree, a hostile work environment. So or a hostile environment, hostile public accommodation environment is sort of a separate adverse action. So in this case, while removal would be considered an adverse action, you can have cases in any of our areas of jurisdiction where someone engages as a conduct, and in retaliation for that conduct, a hostile environment ensues. Okay. So that's the reasoning. I'm not saying that's what you have to find, but
if that volunteer had gone to her and said, "You've got to sit down, it's our policy," and she says, "No, I shouldn't have to," and the agent says, "Yes, it's our policy, otherwise you have to leave," and she leaves, would you say that they had retaliated?
Under those sets of facts,
under that hypothetical,
with a huge caveat that I'm not making any decisions about any kind of facts that aren't in front of me, that sounds like an adverse action, being told to leave in retaliation for asserting a right. If she said,
it focuses our disagreement,
right?
Because it seems to me that that's the adverse action,
right?
Any other commissioner questions for Jane?
Really helpful. Thank you.
Very well.
So we have heard from the parties and the investigator. At this time, we are looking for a motion. There are, my goodness. So
there's
five proposed findings against respondents separately. So up to you how you take them.
I'd like to.
Okay, Commissioner David.
I'd like to take the first two together and the next three separately, because it's going to vote differently on the reasoning ground.
Okay.
But 1 and 2, does anybody object to taking them separately? My motion would be that we find that there's no reasonable grounds to believe that Maine Amphitheater discriminated and no reasonable grounds to believe that City of Bangor retaliated. We've got the retaliation of Bangor up above the finding recommended that we find Bangor discriminating. But anyway, that's 1 and 2, and I would vote to adopt both of those.
Second. Okay. So the motion is to find no reasonable grounds on findings 1 and 2. Any discussion? Sorry, not calling the vote yet.
I'd just say I think it's fairly obvious that Bangor could not retaliate in this circumstance. I know there was some discussion about that before. I just don't see how they could retaliate given their position and the events that unfolded, the way the statute is, yeah, so.
None. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Will I continue or give somebody else a chance? I'd like to go to 5.
Yeah, 5 and 6.
There are reasonable grounds to believe that Waterfront unlawfully discriminated against complainant on the basis of her disability.
Okay.
That's my motion.
Second.
Moved and seconded. Any discussion?
Well, it's the even chance standard that gets me there. I mean, I think there's a lot of facts here that sort of cut either way, but I think there's an even chance that complainant could prevail on recommendation number 5. So.
Any more discussion? Seeing none, if you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay.
Because I don't like 4 and 6, I'm not gonna make it.
I protest. Let's take number 6 then. I move that there are reasonable grounds to believe that Waterfront Concerts, LLC and Production Services of Maine, LLC retaliated against Lisa Caldera for engaging in MHRA protected activity.
Second.
Discussion?
Retaliate you.
So, Attorney Aiello's description of the circumstances, right, as an escalating series of interventions by the venue staff, right? Once she asserts her rights under the MHRA, right, with that pattern and with the even chance standard, I think it's appropriate and certainly defensible to vote that there are reasonable grounds.
I agree. The escalation is the retaliation.
And the reason I'm going to vote against it is because I think that's the discrimination. All these incidents have, not all of them, a lot of them have this kind of explanation. The patron goes into the restaurant with the service animal, and the seating person says, "You can't sit here, you've got to sit outside." And she says, "No, I'm asserting my rights." And she goes to the manager, and he comes along and, corrects it or doesn't. And 2 or 3 different people are involved. It seems to me that there's no retaliation. There's only one assertion of rights. And there's these people running around with their heads cut off, trying to figure out if the policy is still there and what was the policy. And no, you can't. And sorry, you can sit here. And that's not retaliation. That's just stupid enforcement of a discriminatory belief.
Maybe, right, maybe, except for what we heard was the feature that is compelling for me is the growing hostility, right, with respect to house security staff. And again, credibility issue, right? So
security doesn't know what they're doing. Their security is saying, well, what happened here? Oh, you're the official, you say she can't, so you gotta sit down, lady. Okay, I think we've identified them.
The rift.
And Commissioner Walker?
So you don't buy the attorney Newell's
statement that the discrimination itself was the retaliatory action because of escalation after she asserted her rights.
Yeah, so I'm distinguishing it.
So
right?
a 20,
There's two
it's
separate
kind of,
events,
it's a
right?
20-minute, I'm taking, the shorter of the estimate. That, I find that challenging.
I mean, for me, 20 minutes in a Fish concert is interminable.
That alone is been enough.
Time passes very slowly in these concerts. for a
Amy
number
would
of
be
reasons.
very disappointed.
I know. Right, sort of that 20 minutes and sort of the quality of what happened in that 20 minutes and sort of the temporality and sufficiency of time in that 20 minutes, we can go around and around on that, but I do think that sort of discussion, right, meets the even chances of success in trial.
Any further discussion? So the motion is to find reasonable grounds on finding number 6, which is the retaliation by waterfront concerts. If you vote yes, you are in agreement. Commissioner David?
No.
Commissioner O'Brien?
Yes.
Commissioner Walker?
No.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. We got one more.
I'll take that one. So I'll move that there are no reasonable grounds to believe that the city of Bangor discriminated against Ms. Caldera on the basis of disability.
Second. I would have done that, but I didn't want to do it. I didn't want to do the.
So you said
possible.
there are no reasonable grounds.
No reasonable
Right,
grounds.
Yeah.
So motion is no reasonable grounds as to the city. Any discussion?
Yes. Yes. I have 15 or 20 minutes of
Great.
comment. Get comfortable. No, I just feel
Didn't
like
bring my knitting.
Either.
I appreciate that this is a very difficult question and there's no case law and all that kind of stuff. I think that where I come out is I feel like the city had to have done something, and it has to be something more than just being the lessor. That's just how I feel. I mean, I could draw from different areas of law. I know nobody's interested in that, but I just feel like they had to have done something. I don't see what they did, aside from maybe not reviewing the policies, right? But this policy was not in writing. So even if they had asked, right, they probably would not have heard about this policy anyway. So I just don't see it.
Yeah, well, except for the plain language of the statute, right? And so, there's that.
No.
So.
Well, no, because the statute says indirectly. How do they, what does that mean?
Well, we don't necessarily have sort of substantive guidance, right? About what does, in this context, right? What does indirectly mean? So I think we borrow the concept, what's the plain language of indirect? We've got it here and, hopefully we can get some case law about what if for purposes of interpreting and applying this statute for a lessor under these circumstances, it would be incredibly helpful, right, to have case law to tell us how to parse through these issues moving forward. So that, along with even chance, I think, I'll be letting know.
Everybody knows that Commissioner Sanders and I go round and round for hours. I'm just gonna say that I don't think that there's, how are we define indirect? I just don't see how that is met here. That's all.
I asked myself, I agree that, I'm gonna vote that Bangor didn't discriminate. I asked myself, what would you have had them do? How do they approve a concert? I can envision situations in which there would be some responsibility. If the application is from the Ku Klux Klan to hold a rally, there's some sort of notice there. I'm guessing, and I have no idea, it's not in the record, that the entities make applications to use the park on a particular day, and it's rubber stamped by the council on the recommendation of a manager. If they're on notice that there's some obvious reason that they ought to look into this, that's fine. But if it's a music concert, are we saying, as a matter of the commission, that the city has to establish a venue policy review committee to inspect and demand all policies of the provider? to review them. No, this is not, it doesn't rise to that standard.
Sounds like a former select with a council.
Any further discussion? Okay, seeing none, the motion is to find no reasonable grounds on finding number 4. I have the wrong number. If you are in agreement, you will vote yes. Commissioner Davis.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
No.
Okay. That is all of the findings. So thank you, everybody, for your participation and your patience. We will send the parties and council a letter regarding how we will be proceeding.
And the last,
Once we work out who is doing that.
Thank you so much, everyone. Have a good afternoon.
Thank you.
Thank you.
Can we take, yeah, 3 minutes? You haven't had as much time. I'm going back up. Thank you all.
Okay, we'll call the meeting back into session, and the last case for hearing today is Deloge versus CNT Realty. It is a recommendation by the investigator for finding of no reasonable ground to believe that unlawful discrimination occurred, and therefore we will hear from the complainant.
Ms. Deloge, you could unmute yourself and turn on your camera.
Hi, can you hear me?
Can hear you, yep.
Oh, sorry.
There you are, okay. You have 10 minutes. Do you want to save any of your time?
Dr. Kreitzer, he's supposed to be speaking for me.
Yeah. I guess it's, I was going to say good morning, but I guess it's good afternoon, commissioners and committee members. I'm Dr. Andrew Kreitzer. I'm a psychologist at Health Access Network in Lincoln, Maine. Ms. Deloge has asked me to speak on her behalf regarding her appeal. Just to clarify, I'm not an attorney, I am not legal counsel, but I'm acting as an advocate on her behalf. She wanted me to convey the enormity of her distress regarding the reported radio noise that was coming from her next door neighbor's apartment and her efforts to address it, which led to her complaint. And I want to thank you for the opportunity to allow me to do this. I've provided behavioral health treatment to Ms. Deloge since March 5th of 2021. So I've had a fairly long working relationship with her. She has a long history of anxiety and depression, which has required ongoing treatment and care. Over the past, I'd say 6 plus months or so, maybe 9 months, she has talked with me extensively about the difficulties in dealing with her neighbor's incessant radio noise at the time, which, according to her, would start in the evening and would go throughout the night. Most of the nights, according to her, the noise was so loud that it consistently interrupted her sleep. Ms. Deloge reported to me on multiple occasions that the neighbor's radio noise was adversely impacting her ability to fall asleep and stay asleep throughout the night, despite her best efforts to reduce it. She also found that her mental and emotional well-being were negatively or was negatively impacted by the noise. She tried, according to what she told me, she tried a number of different things to deal with the noise, but none of them were rectifying the problem. And at that point, she reported to me that she had a number of communications with the property manager of the complex. But over the course of many visits that we had, she conveyed to me that she felt that she was dismissed in her efforts to come up with a viable plan that could be put in place to remedy the situation. Ms. Deloge told me that the radio noise did not essentially stop until her male neighbor had died sometime in October of 2024. And at that point, she informed me that the maintenance person at the complex had come to her apartment and told her of the plans to put noise canceling spray foam in the walls between the two apartments. She claims that she had not been made aware of this plan prior to her neighbor's death. Thank you very much.
Thank you. Any commissioner questions for the complainant's representative?
Yeah, good afternoon. So
Good afternoon.
whoever, whether you or your person you're advocating for, the complainant, want to answer this, I'm just going to be blunt. Where is the discrimination here? And what I'm saying, I mean, it seems like there was a noise issue, right?
Yeah.
And the landlord was approached about that and offered several alternatives according to this report. And then agreed to install the soundproofing material, and then the person causing the noise passed away. At which point the noise is no more, as I understand it. But in the meantime, the respondent had agreed to install the soundproofing, right? And I think that was conveyed to the complainant here, that they were gonna install it from the neighbor's side, right? They're gonna install the soundproofing. So I guess I'm unclear as to what is the complaint at this point? What's the problem?
Well, I mean, I think I think it's difficult to, and I'm not a legal person, so I'm not here to speak to the legality of this. I was asked by Ms. Deloge to offer, my view of things based on our visits over many months.
Let me help you out, because I understand you're not an attorney, and I'm not asking for a legal conclusion. Let me ask it this way, right?
Okay.
What is it that you're contending that the landlord did wrong?
Well, from what Ms. Deloge shared with me, she claims that she went to the landlord, tried to remedy the situation, once she realized for herself that she could not handle it on her own, and did not believe that the property manager, I guess, acted in good faith and offered viable solutions, and felt like she was being dismissed. And that's what she reported to me.
All right, thank you.
Yeah, you're welcome.
Doctor, among those viable solutions, did she indicate that the landlord had offered to move her to another unit?
I think there was some conversation about that. I think from what I understand, she had gone over to the other units, according to what she told me, and did not find it to her liking.
But it would have remedied the complaint, right?
In theory, it could have.
Thank you.
Any other commissioner questions for, apologies, I can't see your name, Dr. Kreitzer?
Kreitzer, yes. Yep. Thank you.
Any other questions for Dr. Kreitzer? Seeing none, I do not believe that anybody is here for the respondent. I do not, I have checked, they did receive notice by email at least, as well probably as by mail, but they are not here. So I think we will move to the investigator. If we don't have any further questions for the complainant or the representative.
Hi, good afternoon at this point. Everything is in this report. Commissioner Douglas, like you said, I just didn't see where the discrimination occurred here. So I made a no reasonable grounds finding. If you have any questions, I'm happy to answer them.
Seeing none, we would be looking for a motion at this point. There is one proposed finding.
Yeah, I'll move that there are no reasonable grounds to believe that CNC Realty Management and or Jane Potvin discriminated against the complainant on the basis of her disability, and the complaint should be dismissed in accordance with 5 MRS 4612 subsection 2.
Second. Moved and seconded. Any discussion?
Only that I just see no basis for discrimination whatsoever in this case. I don't understand it.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you vote yes, you're in agreement with the motion. Commissioner Davis.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay, so the finding of no reasonable grounds, we thank the parties for their participation, and the commission will send a letter to the parties confirming the results of the hearing. That concludes the business. The hearing agenda. We did the business agenda at 8:30. I need a motion to go into executive session.
So,
I think there's some language that.
yeah.
And just
legal counsel.
No, Ed has
Yeah.
his spiel.
Pursuant to one MRSA section 405(6)(e), I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the rights and duties of the commission and the concerts that she's attending.
Second. Great. Moved and seconded. Any discussion? Seeing none. If you vote yes, you are in favor. Commissioner Davis?
Yes.
Commissioner Ryan? Commissioner Walker?
Yeah.
Commissioner Douglas? Commissioner
Yes.
Sanders? Okay. All right, Chelsea, can you mute us and turn off the video?
Put on the record that said council appears to be physically threatened.
Oh. You might have to.
There we go. Up there, but you're good.
Yeah, it's on the. Okay, so I need a motion not to litigate E 22-0374C, E 23-0313, and H E 24-0123.
So moved.
Seconded, any discussion? None. If you vote yes, you are in favor. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Fantastic. All right. Thank you all very much.
Thank you.
See you in like a month.
Like us.
I tried to make them like